who is a professor of biochemistry, and we have Ifeanyi Anago, is a lawyer, a quantity surveyor, and we have Dorcas Levy Daniel. She is the current director of the Kaduna State Multi-Law Courthouse. We have Professor Andrew Akume, who is a professor of law in Ahmadu Bello University, Kaduna. We have Mr. Nanchan Nangwan, he's a lawyer, a notary public and media practitioner. We have Professor Oladipo Ogbola. He's a professor of mechanical engineering. We have Mrs. Ankama Roskana. She is the chairman of the governing body. She's a lawyer, a lecturer, and a notary public. We have Mr. Fola Alade. He is a lawyer, a notary public, as well as a global mediator. We have Mr. Tolani Oladipo SAN. He is a practicing lawyer. He's a mediator and arbitrator. We have Associate Professor Bossa Rita. She's a professor of English language. We have Mrs. Janet Nanchan. She is a journalist and a mediator by training. So today we bring you our mediation skills for the June, for the September cohort. And without wasting of time, we are going to begin. I have the honor of having here with me the chairman of the governing body of Settlement House Area Training Institute, in person of Roskana Ankama. And we are privileged this morning to have our first facilitator in the house, in person of Keziah Kenneth Azuma. So the chairman of the governing body, please, over to you. Welcome our participants. Welcome our facilitator and declare this meeting open.
Good morning, everyone.
Morning.
Good morning.
All right, thank you very much. I want to welcome you to our module of training. You are in the right place to equip yourself with the arts of alternative dispute resolution. Just like the CEO has explained, our mission is to ensure that all those that are peace lovers and those that are interested in resolving dispute amicably are decorated with the skills of amicable dispute resolution, and Shati is the place for it. So welcome to Shati this morning. I would like to welcome our resource person. He has already introduced me, so there's no need of introducing myself. My name is Roskana Galadima Ankama, like he said. I also welcome the resource person in the house who is already here to take up this training. I believe that after this training, you will be able to do things differently, even from your own personal development, not just resolving conflict for others, but to having peace with yourself, having to do things differently, having to understand yourself, having to understand the society, and then you also have a grip of the current Arbitration and Mediation Act, how it has evolved and how it's been applicable, and how you can take advantage of it, even for professional development and then for career development. So on this note, I would like to declare this meeting open. I wish you all the best. Settle down. Please make sure you attend all the sessions. All the sessions are very, very important. The practicals, the simulations, the theoretical parts, take your notes seriously because you're going to be assessed and then you will get your certification. So I'd like to enjoin you to sit down, relax, ask questions, ensure that you give it the maximum attention because it is a life skill that you will need for your journey, not just as a lawyer or as a professional, because it is open to all professionals. It's not restricted to lawyers alone. Anybody can be an ADR practitioner. And I want to let you know that the market for ADR practice is widening every day. So you are in the right place. You have taken the best decision to get yourself equipped. And therefore, I wish you all the best throughout the course of the training. Thank you very much and do have a wonderful training. God bless you.
Thank you very much, Your Excellency, Mrs. Ruskana Ankama, the chairman of the governing body of Settlement House Area Training Institute. Having received her direction and permission to proceed, I will just proceed by bringing on board our facilitator for today. Our facilitator for today is just a minute. Our facilitator for today is Mrs. Keziah Peace Kenneth Azuma. She's a lovely person to listen to, very calm and humble. And I tell you, you want to listen to her, very soft-spoken. She has been an area practitioner and a lawyer practicing in Ghana. And we are privileged this morning to have her share with us an introductory aspect of this training. So Mrs. Keziah, I don't know if you can see my, okay, yes. Mrs. Keziah is actually called to the Ghana Bar in 2012, and she is a member of the Greater Accra Bar of the Ghana Bar. She is currently the lead solicitor and advocate of Citadel Legal Consult. It's a private law firm in Ghana. She specializes or practices in the area of family law, land law, administrative law, employment law, alternative dispute resolution, among others. I tell you that she has gathered enough experience in the practice of alternative dispute resolution, and she is someone that you would like to listen to. Please, I enjoin you to pay attention, take down notes, and then we are all here to answer your questions where necessary. So, Ms. Keziah, please, you have the floor.
Hello, good morning, everyone.
Good
I'm
morning.
grateful for the opportunity to be here. Thank you so much for having me. Thank you, Mama Ruskana, for that introduction. Very brilliant. ADR helps you to do justice in every matter, not just under the law, but in your homes, in your churches, in the mosque, wherever human beings are found. Conflict is inevitable. Once there's conflict, the ADR skills that we are teaching today will help you to resolve them. So my brother Nanchan will be sharing the slides, and then we'll be discussing it gradually. But you can always stop us and ask your questions, and we don't mind responding. If we don't have a direct response, we'll find the answer and come and give you. Thank you very much. Can you see my slide? Can you see my screen?
Not yet, ma'am.
Yes, I can
the
see.
slide is up
Can
now.
see, ma'am.
I was thinking that you were going to share, but well, let me do my own sharing. I'm sure whether I can share it. Can you see? Senior, please, can you share for me?
Just a minute. Yes. Okay.
I should try again.
Okay, here we go. Can you see the slide?
Yes, I can see it.
Okay.
Okay,
Go ahead,
so
please.
okay,
Can you
okay,
see?
thank you, sir. Yeah, so the history of mediation. So generally, it started in the United States and in Australia. But as we go along, you find that we have been doing mediation as Africans for a very long time before the Europeans found a name and brought it down to us again. But we have always been doing mediation in our homes. But officially, it started in 1970s, 80s, 90s. And then generally, the definition is that mediation works, well, this is from the 2018 meeting in Kaduna. Okay, so that is where the first paper on this matter was presented. Shall we go on? But as I said earlier on, we have always been doing mediation before the United States and United Kingdom and Europe brought it down to us to say, oh, this is called mediation. We've always settled our disputes. So we've always had a way of communicating as Africans to resolve our matters in our various homes, churches, mosques, wherever we found ourselves. Next, please. Hello, next. Okay, so generally speaking, mediation is used to resolve disputes at the communal level, okay? The elders will have a meeting and they will say, let's talk about this matter. The emergence of dispute resolution is usually will be linked up in Nigeria to how the IMCs have been settling the disputes from the 1990s. We're going to be learning the nitty-gritties of how these mechanisms work, but this is how it started in Nigeria. So the multi-door courts introduced mediation in Nigeria. Then the private people took it up and enhanced it. And as we speak now, there are a lot of ADR organizations like the Settlement House teaching mediation, ADR mechanisms, as well as making sure that the practice is entrenched in the fabric of the Nigerian people. So when we talk about the ADR spectrum, we have what we say negotiation, we have mediation, we have arbitration, we have conciliation, we have med-up, and then med-up means mediation will start first, then arbitration will continue. Then we have also the arbitration beginning the process, then going back into mediation. We have expert determination, we have early neutral evaluation, and private judging. So basically, negotiation will have to do with just two people, okay? Me and my brother, we have an issue, but I've been trained in conflict resolution. So I speak to my brother nicely, and then we solve our problem, we go home. If it's a business, the two businesses will meet in the comfort, wherever they want to be, whether they want to do conference room meeting, whether they want to meet over a drink, they will do that and then come with a solution. When we talk about mediation, as for that one, there's a third-party neutral, like those of you that will be training today and training in the days ahead. Once you become a certified mediator, you carry your license, you carry your skills, when people have disputes, you are the third party neutral, and you help them to resolve it. Then when we talk about arbitration, the basic things that I want to say about arbitration is that it is a private litigation, but the person who presides over it is called an arbitrator. Then the arbitrator would pass a judgment after looking at the evidence and dealing with it. Then we have mechanism like conciliation, which is similar to that of negotiation and mediation. Then in the med-up system, you would agree that you would mediate the issue with a mediator as a third party neutral. But then if that is not resolved, you would go into an arbitration where awards will be made by the arbitrator. That is after you have adduced evidence and you have done a private litigation kind of situation. Then the AdMed is where you start with arbitration. So this process must begin by arbitration. You do that, and when arbitration fails, you go into mediation. Expert determination is where somebody is an expert in a field, and you call him to come and make a determination on the matter. The early neutral evaluation, the private judging, all of these things are ADR mechanisms. As we go along, we would go into those details. And we proceed. So why mediation is preferred? In fact, even as a lawyer, I love mediation more than the litigation. Why? We are going to tell you in a few minutes. It is privileged and without prejudice. So people come into the meeting without the intimidating looks of lawyerliness, without a courtroom setting, without any inhibitions, because the process itself enables you to say what you mean respectfully, enables you to develop your own options to resolve the conflict. So as much as possible, you would not be intimidated. You will not be forced to make a decision. It is voluntary, it is open, and all discussions made at these meetings are not sent outside. It is private. You can't send a discussion in this meeting into a courtroom and say that you want to use the evidence that you've gotten in the mediation session. So this is why for me, I would encourage you that you should choose mediation over all the other processes because you can be yourself. It's a win-win meeting and things like that. So usually it is also short, okay? It is short, it is short, it is short. So you start with an introduction meeting, then you go into caucusing. Caucusing is basically when the meeting is not able to resolve the issue, but the neutral want to tell one party how they should look at the situation, how they should adjust and amend. You know, as lawyers, we can tell you how your case will do if you enter the courtroom or the position of the law on the matter. And as mediators, whether you're a lawyer or not, all you have to do is to read up on every issue that comes before you. And once you read up, you can also be able to tell your clients or the parties that in caucusing, this matter, this is how it may end. So I want you to move towards a certain middle point, which will be a win-win. So under the mediation protocols, you would have to understand that we don't take all as winners. We win together. We do win-win things, okay? So the caucus meeting allows you to try and talk to each of the parties as a win, and then bring them back and find a way to actually meet them halfway. But the decision is not for you as a mediator. It is for the parties. So you only make suggestions, you guide the parties, you don't make the determinations for them. You don't insist that they should resolve in a particular way as well. Okay, so as I said earlier on, it is voluntary, you own the process, you are treated, in fact, there's a ground rule for the process. You cannot do certain things when a mediation is going on. For example, you cannot be name calling, you cannot be shouting, you cannot talk out of your turn. When it's not your time to talk, you can't say anything. You have to respect the other party. The neutral is supposed to be very respectful and kind. And a neutral, as a neutral, I want to add at this point that you must be seen as a neutral, okay? You must not be seen as being on the side of one party or the other. You must be seen as a proper neutral. So if you have any issues like you know one party or you know one party's family member, you have to make all those disclosures at the beginning, at the plenary. So the parties will say, I want you to continue. I don't want you to continue. So once they submit to you, you must make sure that you are properly a neutral. And sometimes when we train, we tell you that even what you wear must not be somebody's party color. How you position yourself, how your face expression is. You must try and make sure that you are not seen as being on one party's side against the other. Okay. Okay, it is affordable and less expensive. As much as possible, when we do mediations, even when it is court connected, the court will give you just 1 month. 1 month going to court is less expensive than going to court for 1 year. I believe we all agree. So under that score, yes, it is less expensive. And the parties can also negotiate their fees with the mediator. And usually every mediator, from my limited experience, is very flexible when it comes to fees, because our primary aim is to help. But also I quickly add that I tell my Ghanaian friends when I'm doing facilitation that by all means, you must take a certain fee, no matter how small, because if people don't pay for a service, they don't respect the service. So note that in your mind as you mediate for church members and members of your community. By all means, take some fees, because then they will respect the process, abide, they will submit. Okay, so it is also creative, it's less stressful, gives room for agreements and disagreements, easily implementable. You see, if you study management principles, when people are part of the decision, they easily submit to the decision. But when they are not part of the decision, well, they say, well, this is what they met and say, this is what they are doing. Let them do, let us see. Okay? So people agree to an agreement that they have reached is easier. Okay? Yes. Okay, so it provides realistic views of emotions, positions, and options. Okay, so in mediations, we allow people to cry, we allow people to vent, we allow people to tell each other how angry they are, how offended they feel, and those things. It doesn't happen in litigation. So the parties also decide on where to meet and have the meeting. So they will decide that we'll meet in room A, room B, and room C. Okay? Agreements which will be filed adopted by the court. I think that most of the courts in Africa are now at the point where once you reach a settlement and you file it, it is binding. And I tell the mediation parties that mediating settlements are even more binding than the court judgments. Why do I say so? If you have a mediation meeting and you write a settlement and you sign, and if you provide for witnesses and they also sign, you cannot go to any court and say, I want to change it, I want to overturn it. I did a case where there was a court-connected mediation. So the mediator settled the matter. Then when he settled the matter and they filed it, the other party suddenly went and took a lawyer, and the lawyer filed that they should set aside the agreement that was reached at the mediation. I quickly filed an opposition that said, well, the party can only say I was put under duress, and I was forced to settle. And since that is not the case in this matter, we cannot set aside a mediation agreement that has been properly reached by a court of competent jurisdiction. And that was what ended the case. And we proceeded nicely and moved on, concluded, okay? It helps to restore relationships. Most of the time you are in conflict with your sometimes family member, sometimes spouse, sometimes business associate, sometimes a classmate, sometimes a business partner. And by the time you go into a courtroom and adduce evidence and insult each other and pull your reputations in the mud, everything scatters. It is very difficult for you to go back and be talking to the person and be friends. In fact, I haven't seen cases where the case has been determined and the judge has given judgment and the people go about laughing with each other and greeting each other. I've not seen that one as yet. But when you do mediations, you find that parties are laughing after, they are smiling, because then we help them to, because you are going to generate the options yourself and actually decide the decisions or what the conflict issues are in the mediation by yourself. Parties leave the meeting very happy, very excited, and everybody is good to go. So we restore relationships when we do mediation. So I want you to keep that at the back of your mind, that it is a medium of restoring relationships. That is why there will be the caucus meeting when the tempers are so high and one party is still insisting that I'm on this particular page, I'm not moving to the next page. You have to quickly put your authority down as a mediator and separate them and explain to the other party that this is important as a part of the process to resolve the dispute. Next slide, please. So we have types of mediation: community mediation, neighborhood mediation, family mediation, faith-based mediation, political disputes mediation, workplace mediation, peer mediation. All of these are taught in this institute. And most of the things that we're going to teach you today, all you have to do is to import it and apply when you're in the community. Import the principles and apply when you're doing the neighborhood mediation. Import and apply principles, but slight modification when you're dealing with family mediation. And the same way when you're dealing with faith-based, political, and workplace mediation. All you have to do is to try and tweak it a little bit. Continue to speak to us as your facilitators. Speak to Shati and they will help you to know which things to pull out and which things to add when you have a specific mediation to deal with. But everything you'll be taught this week is applicable to all of these types of mediations. Okay, there are many, many, many more. There are many more because every area has specific needs, specific laws, specific rules, specific applications. So, for example, there are even restorative mediations when you are talking about mediation that has to do with offense, okay, or where the criminal justice system kicks in, the offense is a misdemeanor. There are ways of mediating those ones as well, so that the victim and the suspect will be in one nice place, going home together in peace. Okay, so this is what I spoke about. Okay, so the only mediation, so we have mediation, medical disputes, industrial disputes, commercial disputes, and then child justice mediation. I just spoke about that one. That's where the restorative, well, sometimes when the child has offended the law, that's where we do those ones. The only thing that we cannot mediate is where there are capital offenses, rape, murder, defilement, those cases are felonies. Okay, under the law, they cannot be mediated. But when you have personal injury and I brush your face, you can mediate it. So what does the mediators do? What are the parties' role? what are the advocates' role? So what we do is that we help develop communication between the parties. Okay, we find a way to get the parties to talk, to be non-judgmental. Language is basically guided and guarded, because you see, what you say, the same thing may mean different things because of your mood, okay, and the rest of it. Then your empathy. Okay, then you create the environment for the process to work very well. Then we create a conducive environment. Like, for example, how parties sit, where they sit, who they are with. Sometimes we allow other members of the family to join because they are the power brokers. In some of the mediation sessions, if you don't bring some power brokers, the thing will not be solved. The thing will not be solved. So the facilities, the seating, there has to be a less formal, less official environment, very cozy, very kind, outside of the courtroom stringent environments, okay? But now that there's technology, you can also do mediation online. But we encourage parties to create solutions for their own disputes, okay? We look at it and we say, okay, under this situation, what do you think should be the solution? They themselves will bring out their solutions. We explore perspective of the disputes from different angles, you see? Because when you put 6 down and you put 9 down, depending on where I'm standing, I'll see it as 6 or I'll see it as 9. So we help them to see the dispute from the view of the other party, okay? And then we document the areas of agreements and also the areas of the disagreements. Then we try to manage the mediation, okay? We try to diffuse tensions as much as possible. If there's a certain tension, we quickly close it up so that it doesn't continue. It's so important. Very, 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 very important. Okay. I'm trying to put off the video of this person whose video is showing so many things. Please put me back on the recording. But let's put a video of the other person whose video is showing.
All right, go ahead.
Okay, please open my screen. Okay, so you have to be patient, empathetic, keep everybody informed. It's close and private. So as much as possible, make sure you end. No, the previous one. The one that starts with empathetic. Okay, yes. Be realistic. Okay. And as much as possible, read very wide because of this training we are giving you. If you know a lot of things, you'll be able to resolve a lot of disputes. For example, if I want to resolve a medical dispute, I must go and read on them. Read the issues about the doctors, read what they're supposed to be doing, and try and resolve the disputes accordingly. Then be realistic. You must understand how to analyze the conflict, determine the causes, and gradually help the parties to be able to resolve the conflicts amicably. Okay, so a mediator must understand the types and how to apply them. Okay, try to understand the types of mediation, the personality types. Okay, so how sanguines behave is different from how melancholic behave, different from the phlegmatic. It's also different from the supine. So, for example, when you meet sanguines, they quickly are friendly, they are nice, they want to solve the matter quick, sharp. Okay. When you meet the phlegmatic, they are very slow. Okay, if you say so, I'll see. When you meet the melancholic, they are very moody, they are very calculative. A T must be dotted, so and so must be this. And when you meet the choleric, they are the born leaders. They are in a hurry to take everybody to make sure they are in line with what is going on. That's how the cholerics behave. The supine is a combination, okay, of about 2 or 3 of the temperaments fused together. Everybody, every human being has one of these temperaments being dominant and the other being the supporting one. So you can have a choleric sanguine, a melancholic sanguine, or melancholic choleric, and those things. Sometimes the combinations makes resolving disputes with such people a bit difficult or a bit comfortable. You have to apply yourselves gradually to study all of these things. When the people appear before you with time, as you get experience, you will be able to tell that, hey, this person is a straight choleric, so let me apply a few sanguine and phlegmatic tactics to calm him down, to agree, and to move in a certain direction. So try to, you don't have to, you cannot even ask them. It's part of the protocol. You don't go asking people what is your temperament and things, but it is something that as mediators we should develop gradually by reading, by observing, and by the help of the Holy Spirit. I'm a Christian, so I can only talk about God and the Holy Spirit. So that's how we get the help. Okay, so next slide. Okay, we've come to the end of the first.
So this is the introductory aspects, and also allow the participants to ask questions, areas where they do not understand or they need clarity.
That's true. Is there anything you want us to explain further? Any questions, any contributions?
Okay, so we have had the first introductory aspect of the training. So do we have questions? An overview of ADR. We are going to go deeper into some of the things that we need to do. So do you have any question? If you have a question, you can raise your virtual hand. You can raise your virtual hand. Or you can put on your mic and ask.
Yes, I have a question. Good morning, all.
Good morning.
Thank you. In the course of, thank you, Mrs. Kezia, for this session. I just have a question. In stating the types of ADRs, you said arbitration is more or less like a private litigation. I think I heard you. Yes. So my question is that then what is the difference between the arbitration and is it private, is it, sorry, sorry, please, I think private something, private
litigation.
Private litigation, yes. So what is the difference between the arbitration and private litigation? Thank you.
Mr. Nanchan, can you please help?
Okay. I think she mentioned
private
private
litigation when she was
arbitration
private
when she
litigation
was
when she was
private litigation when she was
The
explaining
private judging,
arbitration.
private judging.
okay,
Okay,
private.
private judge,
Mr.
Mr.
Maren,
Maren.
Yes.
is
Is
it
it
private
private
judging
judging
or
or
private
private
litigation?
litigation?
I think she said private judging.
Okay.
Okay.
Or maybe I didn't get it right.
Oh, don't worry.
Okay.
See, what happens is that when it comes to arbitration, it is just like we do the courtroom practice. You will be asked to present your case. Okay. First point is that you will sue the person in an arbitration court. Okay, that's the first thing you do. Then the person would, as it were, enter appearance and also say that I agree to this, I disagree to this. Then they will set down the issues and say everybody should write their address, present to the court. When that happens, then the mediator, the arbitrator give an award. Sometimes there will be 3 arbitrators. One that you select as the claimant, one the other person, respondent, also select. Then the 2 will now appoint an ombudsman, the third one, okay, as a chairman of the panel. Sometimes they look at the nature of the dispute and select somebody with that specialty to be the chairman. So the 2 arbitrators that are for both sides will be championing the cause of both sides. I don't think that happens in private judging.
Yes. So in private judging is more or less similar to expert determination. But in expert determination, the parties may not necessarily be judges, or lawyers. Expert determination, they could be experts in a particular aspect of law, they could be professionals and the rest. But when it comes to private judging mainly is the use of experienced judges or maybe retired judges. And what you do is maybe you have a scenario or a situation, and then you want someone who has been on the bench, who has been practicing, who has practiced and has retired, and you want the person to give you a fair perspective. Assuming we go to court and this matter is going to be decided, how is it going to go? So when this private judge who is appointed, listen to both parties and then gives his judgment, that judgment will now serve as a basis for the parties to be able to look for a better alternative, whether to proceed with maybe litigation or to adopt a more preferable means of resolution, be it maybe negotiation or mediation. I don't know if you understand, Mr. Maren.
I get you now. Thank you.
All right,
So
thank you very much.
as for these lessons, sometimes you would be able to understand when you are practicing or when you meet the situation, and then you would always either come back for clarification or speak to your friends or read further. In fact, we don't always understand everything totally when we are in these spaces. I mean, that is personally how I have been able to navigate the spaces I've been in. I just apply and move.
All right. So, do we have any further question, please? Feel free. This is your time. ask question. If you do not have question, I'll have question for you. Okay. I can see that it's either we properly understood or we do not understand at all. My question is, how can we discern an individual's true temperament, especially when some people, Your Excellency, someone is asking, my question is, how can we discern an individual's true temperament, especially when someone tends to conceal their genuine intention? I can see Mrs. Ankama is still with us.
Yes.
Your Excellency,
And the experiences will come as you continue to practice. That's what I said. So the
Hello?
intention.
Okay,
Yes.
Mrs. Zaya, let Mrs. Ankama attempt the question.
Okay, all right.
She,
Thank you, ma.
she usually teaches
What's the
us on
question?
emotional intelligence and personality types.
Okay, ma. Thank you. Thank you so much, sir.
Okay, if we have questions, because I'm listening to some of the questions, we'll be having a class tomorrow on personality traits and discovery, and then we'll also have a class on emotional intelligence. I think if we can reserve those questions after the lecture, we'll have a better understanding.
Okay.
Yes,
Thank you, ma.
I will leave you for a while. I have a mediation to attend now, so I'll leave you for a while.
Thank you, ma.
Okay.
Grateful.
All right. So, Ms. Keziah, do you want to say something before we proceed?
What I wanted to say is that, like Madam has said, you would have to learn on it, read on it, and then with experience, when people appear before you, can tell. It's not a one-day thing. It's a gradual process, a growing process. So as you learn, as you proceed, one day, it will just come to you naturally. But it comes through knowledge, also experience, and more practice.
All right. Thank you, ma'am. So, Miss Emanuela, yeah, she's the one that asked that question. You see, there is no way you can be able to squeeze out anger out of someone if he does not have it within. So no matter how you tend to conceal, that's why you are taking this training. By the time you do emotional intelligence and you now do personality types, you will get to understand the different personality from the behavior of someone. You'll be able to know. That's why you are being trained. If you meet a personality, a person, for example, is someone that always wants to win and he wants to be at the spotlight. He is very, very proactive. So when you have this kind of people at the table, it will be difficult for you to say you will not know. So, but when you are taking the training, you'll be able to see, you'll be able to understand that these are the qualities, these are the characters of this particular special person. And this is how he displays it. So by the time you see the symptoms, just like you have malaria, no matter how you hide, if you are sick, even from your mood, it will be seen. So that is how, by the time we take this particular training on emotional intelligence and personality type, you'll be able to clearly understand, no matter how someone is trying to conceal. You as a mediator, you know the style. That's why you're going to learn about questioning techniques. If you want to ask questions that will make somebody to open up, you want to ask questions that will make someone to talk more or to give you a specific answer or to ginger him. That's why we look at the roles of mediators. What are they supposed to be doing? They are professionals. Their aim or their purpose or their being there is to assist the parties to communicate properly. So if they are there to assist the parties, they must have acquired the relevant and requisite skills that they need in order to be able to help the parties communicate. So when you see somebody who is not coming up, that's a junction where you can say, okay, at this point, maybe let's break into caucus. I want to have a personal discussion. Later in the day, we'll have the president of Mediation Training Academy from the Florida, United States of America, to take us on opening statements. So in your opening statement, you'll be able to lay the foundation upon which you are going to write on to do your mediation. So the moment you are able to break the person into a caucus, you cannot have frantic discussion with him. You can ask difficult questions. You can do reality testing. You know, things that when you do in the public, and that's in the joint session, the person will feel that you are biased. When you are personal with the person and you are alone, you can ask all of these questions. Nobody is listening. By the way, everything you discuss, even in the caucus, you cannot disclose to the other party, except if you are given permission. So I know, I hope you understand. Anu, Emanuela. Okay, I believe that we all understood. So do we have further question? If not, okay, yes, I understand. Okay. All right, thank you. Thank you for that response. Okay, so I think with this we have properly explained the first. Okay, so let me ask you a question in just a few minutes. I'm going to point and then I will be able to know who has been following. We discussed about the role of mediators, parties, and lawyers, legal practitioners. So I'm going to ask Comfort Oju, because we are going to be taking attendance and want to know if you are with us. We'll be asking randomly to know. Hope Pobari. Hope Pobari, are you with us? Hope is not okay.
Yes,
Yes,
I'm with you.
I'm with you, sir.
Can you
I was
tell us the
asking.
role of a lawyer? What is the role of a lawyer in the mediation? We mentioned about those are some of the things that you should take note during class and ask. Since you are not asking, what is the role of a lawyer? Is a lawyer actually needed in the mediation session? Mr. Hope is not. I can see Miss Blessing Ujunwa. Can you attempt that question for us?
I'll say that lawyers are like advisors in the mediation process.
Okay, so do they have time for cross-examination? Miss Blessing, do they have
Yes,
time for cross-examination?
whether the lawyers have time for cross-examination.
Yes, since you said that they are advisors, so they are advised, do they have time to cross-examine the parties?
I'm not sure about that. No.
Okay, so in the course of it, you will be sure.
Okay, sir.
Miss Mungo, Teacher Stephen, are you with us? Mr. Stephen, Okay, Mr. Hope says that from what he knows, lawyers don't cross-examine during mediation session. Will someone want to tell us why? Mr. Stephen. Mr. Stephen. Is Mr. Stephen with us? Yes, sir, you can unmute.
I'm with you.
Yes, sir. We asked a question, what's the role of lawyers? And someone says that from his understanding, lawyers don't cross-examine during mediation because he believes that someone says that lawyers are there to advise. So we want to hear from you. Hope say, I think because mediation is aimed at the parties and helping them settle amicably. Okay, Mr. Stephen, what is your perspective on that?
My perspective is that since the aim of mediation is to help parties reach amicable settlement, lawyers in the mediation process only play an advisory role. I do not think there will be need to present oral testimony to warrant cross-examination. If that happens, it means we are deviating from mediation to either arbitration or something like that. That's
All
my
right, thank you
perspective.
very much for that wonderful contribution. So, Abdullahi Kama, can you tell us what is the role of parties in a mediation session? Is Mr. Abdullahi with us? Okay, Mr. Abdullahi is not here with us. Abimbola, in 1 minute. Can you tell us the role of parties in mediation? Okay. Adiza Lawal, can you tell us the role of parties in mediation? From what you have learned. Yes, Adiza.
Hello, good morning, sir. Good morning, sir. Yes, sir. Sorry, sir. I'm unable to answer the question. I've been trying to log in and I've been having problems, so I was not part of the first lesson. So I was just able to log in now or join the meeting now.
Okay, that's fine. All right.
Mm.
Okay. Mr. Maren, can you tell us the role of parties in a mediation from what you have learned?
Okay, I think mediation is largely party driven. It is the parties that state their, let me say, case, as well as come to possible agreement. The mediator is more or less to guide parties into reaching an agreement. So I think the entire mediation process is party driven.
Yes, that's true. The parties are the one who decide who the mediator is. The parties will decide the venue. The parties will be the one to pay the mediator. The parties will be the one to do the discussion. The parties will be the one to set the rules. The parties will be the one to agree on the terms, of the, they are the one to craft a solution that suits them. So everything depends on the parties. Yes, thank you. Thank you very much. So I can see finally Yelekati. Yelekati, can you tell us the major thing that you have learned in this first session?
Temperament. Understanding the temperament of the parties. And in fact, I was just thinking, what about the temperament of the mediator? But since the chairman said tomorrow we are going to talk more on temperament, I decided to hold back my question.
Kachi, I can't hear you. I don't know if I'm the only one.
Okay. Can you hear me now?
Yes.
Can you hear? Okay, I said my one of the major things that struck me on today's lesson is about the temperament of the party. Can you hear me?
What about the temperament of the parties?
My network is bad. Let me.
Okay.
It's important to understand. It's important as a mediator to understand.
Okay, so you can type what you want to say on the platform, and we will read it out to the participants. All right, thank you. Okay, here we are. They share information and express their mind. Abimbola said, parties share information and express their minds, interests, and needs. Yes. Then Oluwatosin. Oluwatosin said, Oluwatosin said, the session has been thought-provoking, laying the proper foundation to the introductory part of the mediation and ADR in general. Okay, thank you very much, Oluwatosin. All right, with this, we have come to the end of the first session. Our facilitator, we are going to be looking at the second session, which is understanding agreements in mediation. Now, before we go to understanding agreement in mediation, you need to know that everything is all about agreement. If parties do not agree to go for mediation, there's nothing you can do about it. So first, their first agreement to adopt mediation in their contract, and then you have when they come to the junction of doing mediation proper, they have what is called agreement to mediate. Then at the conclusion, they have what is called settlement agreement or terms of settlement. So our speaker, please, over to you.
Okay, thank you so much. Good morning again. Understanding agreements in mediation. Please proceed. Okay, so we usually would come into a mediation because we have a disagreement. We are standing at two different places, and we are virtually maybe sometimes fighting, okay, exchanging words, all kinds of things are happening. But when we move towards each other in harmony, then there is an agreement. But it will happen when there is an understanding of the different positions that we hold. Thank you. Please proceed. Everything okay?
Yes, yes.
Next slide, please. So peace is not the absence of conflicts, but it is the ability to cope with it. Everybody, if even internally we have conflicts, we have conflicts with our own bodies, conflicts with ourselves. So to say you are at peace doesn't mean there's no conflict. Mahatma Gandhi says peace is not the absence of conflicts, but it is the ability to cope with it. So the practice, to practice the process of conflict resolution, we must completely abandon the goal of getting people to do what we want. Marshall Rosenberg. You can't get people to do what you want. You have to cooperate with them to come to a resolution of a matter. Okay, the goal of resolving conflict in relationship is not victory or defeat. Okay? When we are doing mediation, we are not planning that somebody will win, somebody will lose. We are planning that the aim is to reach an understanding, to let go, and to be together, okay? We are not asking that we are going to be right, we are going to be victorious, but to reach an understanding and to work together. Essentially, that is what the goal of dispute resolution using mediation is all about. Understanding agreements in mediation is critical aspects, okay? You have to a good agreement, write it well, make sure it is answering to the disputes that will arise when it arises, and you are able to resolve the dispute with your agreement. Some of the agreements that you see are actually dispute documents, because the agreement itself is going to pose a problem if a dispute arises. So the way we couch our agreements is so important and critical, as we have said in the first lecture. It is a work in progress, It's not a final conclusion destination. So gradually, we'll work through and we'll resolve it. Okay. So the meaning of understanding is essentially you have to know about something, the subject matter situation, and then know about how something works or how something does not work. It's not only about working. What about not working? Okay. Next.
Hello.
Next, please.
Hello. Can you hear me?
Yes, please. Can you also hear me?
Yes.
Please, next slide.
Okay.
So we have said that understanding basically has to do with knowing about how something works or how something does not work. So this is agreement. As I said in the first lecture, you see that the two people in this dispute are have the same issue, but they are looking at it from different angles. Okay, one person sees 6 because of where he's standing, the other sees 9. Okay, so we have to come to a place where we agree that just because I am right doesn't mean Mr. Nanchan is wrong. Okay, agreement, what we are trying to achieve is that the situation in which people have the same opinion or in which they approve of or accept something, we have to bring people together to understand the other person's position as a result of the dispute so that we can resolve it. Okay, thank you. Mediation is a voluntary unless ordered by a court. But even when it is ordered by the court, you have to actually submit to the mediation. Otherwise, the court-connected mediators don't have power to mediate. Okay? It is non-binding, it is private dispute resolution process in which neutral person, like those of you we are training, will assist to settle disputes. And in the mediation, the decision-making power resides in the parties, it's in the mediator. When we sit as mediators, we are just facilitating. We are not the ones to make the decision for anybody. Okay, let's move on. Okay, so mediation. Okay, basic tips. We have an Institute of Chartered Mediators and Conciliators. We have Settlement House, ADR, where we do this family mediation, workplace mediation, communal mediation, and all the other ones that we've spoken about, okay? Let's move on. Okay, so these are the basic tips when you're dealing with agreements in the mediation. 1, focus on the interests and not position. Successful agreements normally will emerge when parties move beyond the position they used to hold and shifts. So we are going to encourage you, or the people who come before us, to move and express their needs, their concerns, their aspirations, disagreements, okay, rather than sticking to specific demands and being rigid. Okay. Then we shift and make sure that we creatively fashion out solutions that are mutually beneficial to the parties. Creatively fashion out mutually beneficial solutions. Okay, let's move. clarity and specificity. A well-crafted agreement should be clear, specific, unambiguous. Okay? Ambiguity can lead to misunderstanding. So when you are crafting the agreement, in my drafting class in the law school, they taught us that we should be simple, straightforward. Okay? Balance the human and legal elements, the agreements. Okay? Consider human relationships. Strike a balance between the legal requirements and the needs of the parties. Make sure the agreement is sustainable. Make sure it is also enforceable. Okay? Some agreements are not enforceable, some are enforceable. Make sure that the agreement you have drafted is within the law in your country, which can be enforceable. Let's move on. Okay, so consider the cultural sensitivities of the participants. You see, I'm sitting in Ghana and I'm facilitating in Nigeria. What it means is that I must understand your language, your cultural nuances. If I'm speaking to an Igbo man, I must be able to understand what to do. If I'm speaking to a Yoruba, I should understand. If I'm speaking to Hausa, I should understand. I should understand. Is that okay? Just 1 second, please. I want to read a message and a line. Please, can you send a message to my phone?
Just go ahead.
Okay.
It's direct message to you, only to you.
And I wanted to read it, and
don't worry. Just proceed.
Is everything going fine?
Yes.
Okay,
I
thanks.
should go to the next.
Say again?
I should go to the next.
Yes. And so I'm saying that we have to be open as people who are mediating to the culture nuances of whoever we are dealing with, and then tailor the approach to the cultures as well. As long as we are looking at the law, the human elements, let's consider culture. In the first lecture, we talked about the temperaments as well. All of that is so important. And that is what makes mediation, for me, the best, because all of these needs are going to be met and the conflict resolved. And the people are very, very, very happy. Thank you. Okay, so ensure that the parties fully understand the implications of the agreement. Make sure that you facilitate the process and you help them to agree, okay, to the agreement. When the people agree to any agreement, they will quickly comply with what you have told them. Okay. Anticipate and address potential future contingencies. Be flexible, okay? Accommodate changes. Anticipate the future, because, for example, when some of us started practicing law, there was no AI and too much legal software. Especially when I was in the law school, we were reading from the hard textbooks. Now, when you meet the law students, they don't even have any textbook. All they have is their smartphone or the laptops, and they are good to go. They are working very well with those materials. So in working as mediators, you cannot be stuck wrapping the current generation. You have to be able to think into the future and make sure the agreement is going to accommodate some of the future occurrences, depending on the area in which you are mediating on. A well-crafted agreement should be robust to be able to stand the test of time and stand unforeseen developments like COVID-19. Let's proceed. Compliance and mechanisms. Consider incorporating mechanisms for monitoring and enforcing the compliance. Define the consequences for non-compliance. Establish a framework. Okay, this helps maintain accountability. You can have agreement that doesn't talk about people being accountable and being held by the book. Drafting with neutrality. A mediator, your role is to remain neutral. Okay, when people settle, put down what they have settled. Don't add your own. Be meticulous. Be meticulous. Be serious. Be consistent with what the people have said that they want to do. Don't add things that has got nothing with the parties. Okay. Education empowerment. Empower the parties about the content of the agreement. When parties understand what they are doing, they will quickly align. Quickly. But if they don't understand, they will not comply. Continuous improvement. Reflect on each mediation experience to refine your approach to drafting an agreement. Continuous learning and adaptation. Every time you settle a dispute, you learn a new thing. Every time you encounter new clients, you learn a new thing. Even in the legal practice, we are always learning. So sometimes when the client sits before us, when you start your story, you're able to know where the story will end. I say, oh, is that so? I say, yes, because we have been doing some of the issues over time. We can tell, okay? Get feedback, do peer review, have others in your cohort you can call to support your growth, okay? Agreement in mediation is fundamental for many reasons. They include one, the voluntary process. The parties must agree that they want to resolve the matter voluntarily, okay? Any resolution reached through mediation is based on mutual agreement of the parties involved. 2, control the mediation. The parties themselves control the mediation with the help of the mediator, okay? So the judge's decision is final and binding in a court case, in a litigation. As for mediation, the parties themselves decide that this is our agreement, this is what we want. And that will be final. Then mediation preserves relationships. Okay, the parties' relationship will be preserved once we draft the right agreement. When parties agree on a resolution, it's likely that it is sustainable. The relationship will be perfect. Okay, it is fast, very, very fast. I remember recently I resolved a dispute within, I think something that has lasted for years. I resolved it within 4 hours. I made sure they didn't go home. So we were taking breaks and breaks. Within 4 hours, we resolved it. Okay. Then it reduces, it's very, very confidential. So the things that you discuss in the mediation cannot be collected and sent into a courtroom. Okay. So, and you can't also go and discuss it with third parties who are not part of the process. If anybody is a power broker in the mediation, they must come for the meeting. Okay, so it's very confidential. Usually when you do a mediation settlement, because the parties agreed, they comply. It's like night follows day. They comply. Then reduces stress and hostility. That is targeted at litigation. As for litigation, it is your case against my case. And then we are always firing things and saying all kinds of things that would virtually destroy the other person because we want to win. Okay. For example, one of the rules in litigation is that discredit your opponents with statements, witness statement. Now we are doing witness statement. Discredit your opponent's evidence, do this, do that, all kinds of things that will pull the other party down. That is what we do during litigation. In mediation, we don't do that. We don't pull anybody down. We support all parties to win. We win together. Okay. So dispute resolution clause, when drafting an ADR clause, it is crucial. This one is when, before the disputes will happen. We are trying to let you know that in any legal agreement or in any contract document that will come to you as a trained ADR practitioner, I believe that you'll be training and become a paralegal and all of the rest of it. So you will have agreements coming before you as an ADR practitioner. When you are drafting a dispute resolution clause, make sure it is clear. Don't draft clauses that will result in a new dispute because the clause is not clear, the clause is ambiguous, the clause is haphazardly done. Okay? No. Draft clauses that are clear, concise, specific, that speaks to the issues. Okay? It's also wise to consult legal people to let them help you. We will not collect too much money. We will help you, and then we share fees. But don't hide the agreement, because if you hide the agreement and there's trouble, you may not even be able to use it to resolve the dispute in the first place. I'll move on, please. Okay, so this is a sample mediation agreement that we can all see. So it says this mediation agreement is entered into by and between the parties, Mr. A and Mr. B, okay, for purpose of establishing a framework for mediation process in the event of a dispute or conflict arising out of or related to their business relation, contractual obligation, or any other matter agreed upon. Okay, this is a very generic agreement. So adopt it, add your language to it. So party A will say, this is the party, this is the address, this is their email, telephone number. Then party B, their name, their address, their email, and telephone numbers. Okay. So the agreement serves as a roadmap. In every contract that you are drafting, you have an ADR clause inside. It serves as a roadmap for mediation when there is a dispute. So please look at the following things that are critical to be inside the agreement. You have to identify who the parties are going to be, identify the scope of the mediation. Is it a family mediation? Is it a business mediation? Is it a medical mediation? Okay. What kind of mediation is it going to be? All right. Then how are you going to appoint a mediator? It's important that you put confidentiality clause inside. If it's not confidential, I cannot participate, because I believe that mediation proceedings have to be confidential. It has to be voluntary. Okay. Parties should say, I agree to submit, I don't agree. Then the procedure, the fees and the cost, the fact that it is legally binding, which is always the case. That's why we will choose that over litigation. And then look at the governing law. Is it contract law? Is it maritime law? Is it aviation law? Is it family law? Under the Ghanaian family law, you cannot put a family matter to mediation in terms of the resolution of the marriage. But you can put the issues about other things, ancillary reliefs, to mediation. You get it? So what does your law say? Look at it. Then what's the signature? As much as possible, whatever you are dealing with in the agreement, try and consult the law that is required, or call the lawyers and then let them help you to fashion out what the governing law says about that particular area. Then you quickly put it down. Then you are good to go. You are collecting your fees and sharing fees. Let's move on, please. So when we finish the mediation meeting and the parties agree and they sign an agreement, we call it terms of settlement. Okay. Anytime a dispute is resolved and parties agree, we call that agreement terms of settlement. And as for the terms of settlement, it is binding on the parties. The court will enforce it to the latter. Okay. So it is embody the formalization of the resolution reached between the disputing parties. This formalization often takes place as a written document. Always write your agreements, okay? And then put the conditions down, how the parties have agreed to resolve the dispute, line after line. What are the rights? What are the obligations? What are the remedies? What is the way moving forward? What's the legal provision if parties breach the agreement? All of that must be part of the term of settlement. Then you make parties sign quickly. Don't let them go home and come back. They will change their mind. So terms of settlement is a document generally that includes the following: introduction. Okay, so the parties are Mr. A and Mrs. B. Terms and conditions. It would then to put the addresses also there. Then to put a small matter about what the dispute is about and why they are before the mediator. If it is a private mediation, if it's a court-connected mediation, why they are before the court, and at what point did the courts send them off for mediation to be tried? At what point did the parties come to you as a private mediator? I put it there at the beginning. Then terms and conditions, you outline what the rights of the parties are, what the obligations are, the issues about financial compensation, performance of certain actions. The parties will be relinquishing some claims because the mediation is a win-win. So you win A, I win B, you win C, I win D. That's how we go about it. Then release and waiver. It often includes clauses where parties agree that I'll waive this and I release this one. Then confidentiality, where the restrictions are that you don't go and even share the agreements. The reason why you even came for mediation is because you don't want publicity to your dispute. So you cannot finish mediation and go and publicize the dispute. If you check, there's no record anywhere of any mediated settlement. But with permission, you have records of arbitration that has been settled. Let's move on, please. Okay, so enforcement. The establishing the mechanisms for enforcing the terms of the settlement includes consequences of failure to comply. So if you don't comply with the agreement that you yourself have signed, the other party will go to court and it will be enforced. Okay, so signature and the date of the agreement. And sometimes you have witnesses. Okay, depends on the kind of dispute and the parties' agreement. You can have witnesses to the agreement as well. Okay, mediation process. In the event of a dispute, controversy or claim arising between parties, both parties agree to attempt to do mediation. Okay, it's usually a process where third-party neutrals like us would engage the parties and then try to settle the disputes. Where the parties don't have an agreement as to who to choose as a mediator, they could come to a settlement house and they will pick one of you to settle their dispute for them. Or in the agreement, they could have a criteria for selecting the mediator. For example, we want a mediator who is specialist in construction law, or a general construction certificate, or a project management consultant, things like that. They could be put there, the agreement. Okay, so the parties would, before they start the mediation, will sign what we call mediation agreements to mediate. Okay, you cannot go into a mediation process as a mediator without the parties themselves signing the agreement that yes, we are here today, we are going to mediate, and we agree to mediate. If they don't sign that agreement, don't proceed. It means that you don't have power to preside over the meeting. So mediation's goal is usually or mainly to reach mutually accepted resolution of the dispute. Every dispute can be resolved unless the law says it cannot be resolved. Okay, unless you have a local law that says these particular disputes are not amenable to ADR. But barring that one, you can always resolve any dispute at all. You don't need to go for litigation. Okay, so next slide. These are our concluding remarks. Mediation is dynamic. You need to understand law, but you don't need to be a lawyer. So all you have to do on the law side is to read. Okay, there are some mediators who are not lawyers, but they are very good. And the only difference I tell them is that you cannot dress and appear before a court using your wig and your gown, but you can challenge any lawyer who is misbehaving because you have serious legal knowledge. So we charge you this morning to decide that you will be learners forever, reading and reading and reading. And then you also need to have a friendly disposition, interpersonal skills. You have to be aware of the cultural nuances of the people you are dealing with. Last week, Friday, I followed someone to campaign in the north. And in greeting them, we had to be bowing. You have to learn all of that to win people over. Their commitment to fostering mutually satisfactory outcome. Okay, navigate the complexities with sensitivity of experts. Be sensitive to everybody that you meet and gradually move on to the international skills. Like this morning, I have a privilege of talking to you from Ghana. So I'm in an international space and I'm grateful to God for that and grateful to my senior Nan Chan. Then the terms of settlement within this context represent the conclusions that have been reached by the parties, not by you. Remember that as a mediator, you are just a third-party neutral, guiding parties, supporting parties to resolve their dispute. You are not the judge. You are not the one to make a determination. Then the terms are meticulously crafted, okay? Make sure you write the terms well. There's no ambiguity in the terms that you've written. And then finally send the people home. I thank you very much. Is this the last slide, please? Yes, so we have reached an agreement. I thank you so much. Thank you, Settlement House. Thank you, Senior, for having me. Thank you all for listening.
Thank you very much for that wonderful presentation. I was listening keenly to see to what you've been saying, and it has been very interesting. So we have looked at agreements in mediation. So the floor is now open for parties, for participants who may have comments, questions. You're up. Questions, please.
Okay, thank you once again. If I may ask question.
Go ahead.
All right. Thank you, Ms. Kenneth, for the presentation. Now, I think in the opening remark by the director, he talked about, and then of course, towards the conclusion, I got to understand that before the commencement of mediation process, the parties ought to sign an agreement, a document, wherein they are consenting more or less to enter into their mediation process. What is the name of that document, please? And can one have a sample of it?
It's
Thank
called
you.
a consent to mediate.
Thank you. And is it possible one has, how it looks like?
Yes, I think it can be shared subsequently.
Yes, Mr.
So don't worry.
Madam, we will send you in fact, you are going to do practical. So all these agreements, you are going to put them into practice. So a sample of agreement to mediate, opening statements, all of those things, you will get to have them and you will see them in the course of the training. Is that okay?
It's all right. Thank you.
Thank you very much. Jean Marie.
Yes, sir.
I see your hands up, please. Go ahead. You have a
Uh,
question?
all right, thank you. I have a question concerning on basic tips on the elements called balancing legal and human element. I want to ask this. Is it professional to include the legal concepts and law clauses within mediation process?
Your question is that can we add the legal courses to this one? Please, is that your
Yes,
question? I want a
yes.
clarification.
My question is about the balancing legal and human element while mediating. So I want to ask if it is a professional to include legal clauses during mediation process.
And generally, because it is not supposed to be seen as a legal meeting, we don't encourage that. But as a mediator, you must appreciate the area of law and the legal requirements as you sit there to guide the parties. Okay? So that's why we say that use balance legal and human elements. For example, there's a legal position in every area of conflict. And there's also the human side of every conflict. There's also the cultural side. In fact, there's sometimes even the religious side of particular conflicts. So a mediator's role is to be able to sit there and balance the acts and drive the parties into developing relevant options, questions, till they themselves arrive at the solutions. So you would have to be able to, for example, if you are dealing with a maritime dispute and you are not a maritime person, you are not even a lawyer, you have to read about it. You are dealing with something about juvenile justice. Two children are quarreling. They are minors, so below the age of 18, there's a provision in the law that supports ADR. If you read about it enough and you go as a mediator and you are helping the children and their guardians to resolve the disputes that has brought them before you, you will be better placed, especially when you have the caucus meetings. So you can go into a caucus and say, oh, the law says this about what you have done. So when you go and beg. or what you have done. If you go to court, this is how much money you will lose because you made A, B, and C mistakes, which are not supposed to have been made in this particular business setting. So try and mitigate the loss to the other party by suggesting A, B, and C. Okay, let's say that there's an oil spillage and the law is very strict about liability when you spill oil, and the community has come to say, settle us. That is not the place to come and be shouting about it is not caused by me and the rest of it. Is it your company that caused it? Is it whatever caused it? You have to look at it legally and then try and look at the community's position and find a way to box the people together to push them in a direction that allows them to settle. So in that case, you have to look at the legal premise, look at the human issues, look at the losses that has occurred, find a way that makes sure everybody is happy. So for example, in Ghana, there was a certain blast in a certain community that killed so many people. It was a very disastrous thing that happened about a year or two ago. So what the government did was to go into a negotiation and build houses for the affected people. Unfortunately, the people started fighting and saying that you didn't build for all of us, so we will not allow those that you have built for to enter the house. If you are a mediator and you are put into that meeting, what do? You would look at the situation, you look at the issues, you look at the legal issues, you look at the human issues, and then you try and speak to the parties differently so that you will bring them into a certain conclusion and make sure that what has been built is used. And if they need to build more, they build more. If they cannot build more, but they can compensate the other side too, that too will be done. And then you would have resolved the dispute beautifully.
Thank you very much for that question and the answer given. Mr. Jamare, are you okay?
Yes, sir, it is okay with me.
All right, thank you. Mr. Hope, Hope, your hands were up. Your hand? Mr. Hope, Mo. You can ask your question. Hope. Okay. Do I have further question? Okay, can we take
some
it?
questions in the chat box. How do we have access to the course materials? It will be shared. From what I know, lawyers don't cross-examine during mediation. Yes, lawyers are not even sometimes allowed into the mediation. If they will come and cause trouble, we put them out. But otherwise, they will sit down as observers and watch the session. That is why we are asking you, whether or not you are a lawyer, read up, and be strong in the particular area so that when the lawyer even comes, they themselves, they would submit to you and know that in that meeting, you are the mediator and you are on top. So I think because mediation said, okay, yes, settle, yes. They share information and express their minds, interest, and need. I don't know whether that's a question or it's a contribution. Okay, somebody is happy with
the question here is consent to mediate different from the agreement?
Yes, it is. It's different from the agreement. Consent to mediate is actually done. People sign to the consent when they enter the meeting room for the mediation. But the agreement is actually signed when you are doing the business document. That is where we sometimes add it to the business document, or we'll do a separate document for you. . Yes, so that is it.
Okay, so peace, Bolaji. You know, as I stated earlier, there are two sets of agreement you need to know. Now, informal contracts, you see that when you are drafting your agreement, especially as lawyers, you include dispute resolution clauses. So those dispute resolution clauses will clearly state the dispute, how you will resolve dispute in case if dispute arose. So you can state it that if a dispute arises, that's also an agreement. In arbitration, in fact, in arbitration, where there is an arbitration clause, once there is a dispute, you cannot go to court. You have to go for arbitration. And that arbitration has to be decided before anything. So if you say you want to go for arbitration before you go to, if you say you want to go for arbitration before you go for litigation, eventually you may not go for litigation because definitely you must settle at arbitration. Arbitration, the arbitrator will give an award. So that dispute resolution clauses are usually found in agreements where parties have agreed on the way and manner they will resolve their disputes where it happens. Then the other one is where the dispute arose, but there is no dispute resolution clause. Parties can actually agree on the way to resolve it. We call them dispute resolution clauses. And most big organizations, every standard contract will contain the way to terminate the agreement and the way to resolve disputes where they arose. So the essence of all these things is so that you can avoid a situation where there is a dispute and the parties are not agreeing on how to resolve it. So prevention is actually better than cure. You have already stated how you will resolve that your dispute through negotiation or through mediation. So that's the first stage. If you wait until a dispute happens and it happens that the parties are not agreeing, you have to start approaching the court to appoint or to compel parties to to enforce your agreement. So, and that is not good enough. So as lawyers and as trainers, we are going to give you possibly a sample of mediation clauses for settlement house so that you can include it in your agreements. You have clients who bought land, and you want them to draft agreement, even in their deed of assignments and all of them. If there is a dispute, you can say that this dispute will be resolved through negotiation. If negotiation fails through mediation, or if mediation fails through arbitration, through the settlement house, or you say yes, the settlement house will be the one to assist in the resolution of this dispute. That's the first aspect. Then the second aspect is parties have not decided, like here we are talking about mediation. Parties have agreed that they are going to resolve their matters through mediation. Now you have court appointed, and you have court referred mediation, and you have voluntary mediation where parties agree. If it is cost or it is private, all of them, by the time you come to the table, you want to start your mediation. To avoid a situation where a party will engage in the mediation session at the end of it, when you're about to take decision, then the party will say, I just came to see and observe how the thing is going. Now that I've observed, okay, I will get back to you. No. You are supposed to also, as a mediator, collect your fee before the commencement of the session. It's not the lawyers that will go when you finish and then you will now be asking your client to pay. No. Agreement as to confidentiality, as to enforceability, as to post-agreement conflict or disputes, as to the fees of the mediator, and how it's going to be paid, is going to be shared equally by parties. Agreement as to the venue, agreement as to the mediator will not be called as a witness in any of those things. All of those things are going to be part of the agreement to mediate, so that the parties, assuming they are not conscious, they will not be conscious by the time they collect the document and they look at it. Agreement to mediate, you are saying that we are submitting. Then the issue of voluntary submitting yourself to the arbitration, that you are going to do your conversation without prejudice, and then you will be frank and open, coupled with the fact that, you know, whatsoever you discuss will remain within you. Aha, that is the point. That is the agreement to mediate. You can make it as simple as possible, not complex, because we have non-lawyers who may not be conversant with many of those processes. So with that, you discover that parties, when they sign agreement to mediate, that's the first thing they will sign before you proceed into the mediation session. Are we together? Are we together?
Yeah.
Yes, we are.
Yes, sir. Yes, sir. We are together.
Okay. Now, when you now sign the agreement to mediate and you now discuss and you mediate and the parties are fortunate to settle, then that is where you go for what is called terms of settlement or settlement agreements. That is the conclusion of the matter. Parties will state simply, there is a dispute between A and B. A and B was supposed to supply this, and then he fails to supply after he has received the payment for the supply. And then they have now discussed and mediated, and this is the terms of the settlement. You just list out basic things. Okay, he has agreed to refund the money, and the money will be refunded within 1 week, and it's going to be paid in 2 installments. The first installment will be paid 3 days. The second installment will be paid after. You know, this agreement is binding. You know, it's confidential, but for the purpose of enforcement, to be taken to court. All those simple things to state clearly what parties have agreed and what that is done. You have covered the dispute resolution clause as an agreement. You have not covered agreement to mediate as an agreement, and you have not covered the conclusion, which is terms of settlement. Please, is there anybody who does not understand this?
Sorry, sir. It's not that I don't understand, but because of network issues, I didn't hear the first part before agreement to mediate, sir.
Okay, but do you understand now? Adiza, do you understand now?
Sorry, it's not that I don't understand, it's that I didn't hear it, sir. Because of network issues, I only was able to
Okay, you do not hear agreement
get
to mediate.
agreement to mediate and terms of settlement. I've heard it is the one before
Agreement to
that I
mediate or
didn't
terms
hear,
of
sir.
settlement.
I've heard agreement to mediate and terms of settlement, but I thought there was a first one.
Okay. The first one is dispute resolution clause.
Okay, dispute resolution clause.
Now, most people, you know, as you are undergoing this training, we will urge you, when you are drafting your agreement, please put settlement house dispute resolution clause in your agreements. Be it tenancy matters, be it contract, be it land, and all of those things. Ordinary contract between the parties. What dispute resolution clause does is it includes the jurisdiction of the court voluntarily. You know, parties have the right to go to court when a dispute arose. But parties can decide to waive their right to go to court and say, this is how we want to resolve our freedom of contract. We don't want to go to court. So before the dispute arises, you have a contract, you have an agreement, business agreement or partnership, and dispute is something that will eventually happen, whether you like it or not. So instead of you to wait until that time, you can now clearly state the way and manner you want your dispute to be resolved before it occurs. You are not praying that it will occur, but it will be worse if it occurs and you are not prepared for it. So these dispute resolution clauses are usually found in your agreements. When you are doing normal agreement, when there is peace, you say, assuming something happened, you say, I should do this, or money comes in and I'm not able to give you your own part. What do we do? Simple. We are going to resolve it through negotiation between us. If it fails, we are going to invite a third party to help us negotiate a mediator. If it fails, we can go for arbitration. That is what is called dispute resolution clause. Most formal agreements, big companies, they have this dispute resolution clause. For you to have a comprehensive agreement or contract, you must carry termination clause and dispute resolution clause. So it is advisable for you to put this dispute resolution clause in all your agreements so that it will clearly state how you will resolve your matter in case it happens. Aliza, are you okay?
Yes, I'm okay, sir. Thank you.
All right.
I'm up to date.
All right, okay. Thank you very much. Ms. Keziah, I think can we actually say that Keziah has done justice to all this and you have understood what she has taught you so that we can release her or call her back? Participants, I'm asking you, can we say that she has done justice to it, or there are aspects you do not understand? Can we say that you have understood the two aspects of the class she has taken?
Generally, all must have been understood, sir.
Okay, thank you. I can see Miss Stephen. You want to say something? Okay. They have all given you an applause. I can see from the chat you have done justice. You have answered their question. They have asked questions and they have clarity. I want to appreciate you, especially on behalf of the management and the governing body of Settlement House ADR Training Institute, for the wonderful session that you have made and for the knowledge that you have impacted. We are very grateful. We look forward to seeing you again either tomorrow or next or thereabouts. Thank you very much for doing justice to this. Thank you.
Thank you so much for the opportunity. I'm very grateful, sir.
We are grateful. Thank you. All right.
Permission to run away?
If they need you, we are going to bring you back from Ghana.
Thank you, sir.
All right. So we have been sitting for 2 hours. I just want you to stand up wherever you are sitting. Just stretch yourself for 1 or 2 minutes. Just turn around, stretch your body as we go into the next class. Please, wherever you are, you can put on your camera so that we can see that you're actually doing it.
So, aha. Then I can see you are the only one that is actually exercising a little. Just stretch your body, stand up, so that blood can flow on your system, and then you can now have. Aha. So we are going to be going to the next class without waste of time, so that after the class we can take our break and then come back for the next class before we finally close. So we are going to be taking all right. Thank you very much for being with us thus far. I want to get to hear your feedback. Are we all understanding? Are we together? Yeah, this is a comfortable junction to take one of our attendants. So may I call on all of you to put on your cameras? We are going to take a snapshot. Once you are not part of the snapshot, it means that you have not attended the first morning session. Because, people will just be jumping and so thank God our facilitator is here. We'll take our pictures. Can see the beautiful faces.
I almost missed the picture.
No, you cannot miss the picture. Aha. Yes, look at these beautiful and wonderful faces. So you have training mates that you cannot say, oh, this is my classmate, this is my classmate. You can't say it. So please put on your cameras. Let's have the first attendance, and then before we go into the afternoon session, and we will ensure that everybody is in. I can see Rene. How do you call it? Is it Rene Bigaruka? Bigaruka from Rwanda, right? Compassion. I can see you. Wow, this is wonderful. Yes. Oh, Onela. Is it Onela? Can you call that for us? Peace, biology. Yes, thank you. At least we can see your face. Uh, Mrs. Asabe, Mr. Steven, we are waiting for you. Comfort. Onela, please let's put on our cameras.
Can you see me now, sir?
Yes, I can see the beautiful you behind the camera. Yes. Thank you. Yili, we are waiting for you. Your camera is on, but we are not seeing you.
Okay, I'm coming, please.
Okay. Emanuela. All of a sudden, all these people are coming back. Oh, we have not taken.
Oh, sir, I've been following on YouTube.
Okay, these people are coming back. We were 20, all of a sudden want to take attendance. Now the attendance is increasing. What is happening? Okay. Put on your camera. Let us see you. We want to see who is behind the camera. Asabe Abubakar. Please. Okay. So I think if others are not going to put on their cameras, we will not know who is behind the camera. We are going to take our best attendance. See, you can't see. You don't want us to see who is behind the camera. Please take note of your classmates. So that when you see them, you say, oh, I will train with you. You don't just train with a particular name that you don't know. Yes, okay. I think we can take our camera now. I will take our first attendance now. After the count of 3, I'm going to be taking. Vanshak, we want to see you. Okay. Here we go. Yes. Peace, Bolaji. Adeumi. Your camera is not on. I think we'll not waste more time. All right. I think we are good to go. So if you want to remain like this, please remain so that we'll be encouraged by seeing you. Our facilitator, where is she? Miss Keziah?
I'm here.
Okay.
I'm not in the pictures.
I cannot see you. Okay. Let us
Then you have to take another one, please.
We'll make you a spotlight. Okay, so take your camera a bit so that we can, the thing is cutting. Beautiful. So let us have only you and the participants. This is good. Okay, let me take other participants. Yes. Oh, this is good. Okay. Everybody is included now. All right, thank you very much. I think permission to
Thank
you are in the lead.
Thank you so much.
Thank you very much. All right, so we're going to go into the next class. So okay. So we are going to be looking at one important and interesting aspect. How many of you believe that if you're a Muslim or a Christian, that our religions actually subscribe to the use of ADR, mediation, arbitration negotiation. Do you believe it? If you believe, can you give me a thumbs up? Blessing. Okay. All right, we're going to be looking at very interesting aspects it has to do with the legal as well as the religious framework for ADR. Are we together?
Yes, sir.
Yeah.
Okay.
Yes, we are together.
All right. Oh, Mr. Samuel, His Excellency the Ambassador is here. Mr. Samuel.
Good morning, Prof. Can you hear me?
Yes, I can hear you. Okay, you can
Morning,
go
Prof.
ahead, sir. We have with us, you can go ahead.
Thank you, Prof. Could you just give me 60 seconds, please?
Just a minute. Just a minute. Here with us is one of our faculty member, an ambassador of peace, someone who is very passionate. In fact, he wants to speak. It's not feeling too well, but because of all the participants, he said he wants to actually add value to them, and he's here with us. And without waste of time, I'm going to be calling him up to take this very, very important class. Before we go into that, briefly, this is who he is. His name is Ambassador Samuel Orobosa Osaren. He's a certified peace and security consultant. He is a chartered human resource consultant. He's a fellow of the Institute of Chartered Mediators and Conciliators. He is a member of the ICMC ODR panel of neutrals. He's an associate of the Standing Conference of Mediation Advocates. He is a resolution specialist at the ICMC ODR Center. He is a full member of the Nigerian Institute of Chartered Arbitrators. He's a faculty member of the Nigerian Institute of Chartered Arbitrators. He is a faculty member of the Settlement House ADR Training Institute. He is a fellow of the Chartered Institute of Human Resource Management. He is a fellow of the Institute of Global Peace and Conflict Management. He is a member of the Society for Peace Studies and Practice. He is a program associate at the Multi-Door Court House. Is an association of Multi-Door Court House in Nigeria. And he is the DRO dispute resolution officer at the Edo State Multi-Door Courthouse. We are actually fortunate and privileged to have him. He is a pastor, he's a man of God, he's a lover of peace. He is a teacher to the core, and you will not just I don't know how else to describe him, but when you listen to him, you'll be able to know better. Thank you very much, Mr. Samuel, Ambassador Samuel, for being with us. You can take the shortest time possible to conclude, and then we will take it over from there. Thank you very much, sir. We're happy to have you.
Thank you very much, Prof. Nachang. Good morning, good afternoon, good evening, good day to everyone joining us today. It's a pleasure to be with you here. Permit me to say Happy New Month. I may be meeting most of you for the first time in this month. So Nachang, can I please have permission to share my screen if you don't mind, please?
Please go ahead.
And let me appreciate you for that wonderful presentation, sir. Awesome. I'm being told only host can share screen.
Just a minute.
The topic for discourse in the next few minutes, approximately an hour. Thank you, Mr. Jean, for your message on the chat box. I appreciate it. We'll be looking at legal and religious framework for alternative dispute resolution in Nigeria. We must understand that the fundamentals of any concept must be properly understood if we are to make significant progress in a particular venture.
You can go ahead, sir.
Thank you, sir. I appreciate it. In the next few minutes, we'll be looking at a very interesting topic. And please, I will appreciate if we do well to pay perhaps attention. If for any reason you need to draw my attention, please use a virtual hand or drop your comments on the chat box. The topic we are looking is legal and religious framework for alternative dispute resolution. And I'd love to begin with an opening quote attributed to Abraham Lincoln. He said, "Discourage litigation, persuade your neighbor to compromise whenever you can." Now, in the next 50 to 60 minutes, I should be able to share some experience with you regarding religious framework for alternative dispute resolution, legal framework for alternative dispute resolution, and look at how the Nigerian law facilitates compromise and amicable dispute resolution. I should also be able to look at some Supreme Court judgment that gives validity to alternative dispute resolution. While I make progress, I will want to ask, I know we all know hand gloves that are being used by medical practitioners or even in our homes. The purpose of the hand glove is to protect our hands. But usually, the way it appears so fragile and shapeless. It takes proper shape when we put it on our hands. And that is what framework is to a particular policy. If there's no framework, no policy thrives. If there's no framework, there's no background, there's no foundation, there's no basis for anything to make significant and appreciable progress. And that is why this day we want to look at a very fundamental perspective as we begin our journey into alternative dispute resolution. You all will agree with me that as long as the earth remains, dispute among individuals, organizations, states will never cease. In fact, it is a well-known fact that disputes are inevitable. Disputes have become a part of our daily life. Almost established that dispute itself is not as bad as people think, but the most important part of dispute is how we handle it, our reaction to dispute can either escalate it or de-escalate it. So what is most important is our reaction to dispute. Now, this session is more of giving information behind the framework for alternative dispute resolution. Looking at it from the legal perspective, we have different laws that validate, different laws that support, different laws that approves alternative dispute resolution. We have the Singapore Convention, we have the New York Convention, we have both local and international laws, we have rules of courts, Nigerian Cooperative Society law, the Evidence Act, Industrial Inspectorate Act, Mineral and Mining Act, the National Health Insurance Scheme Act, Nigerian Telecommunications Commissions Act. We even have the Arbitration and Mediation Act 2023. In all of these laws, ADR is upheld. ADR is highly sustainable. Now, we want to establish that there's no law that prohibits mediation in Nigeria. So what you are coming into, this process that you are beginning today, is not at variance with any known law in Nigeria. Now, instead of prohibiting, we have some court rules that permits judges to encourage parties to resort to alternative dispute resolution. There's a well-established synchronized connection between the courts and alternative dispute resolution. In some states where the facility exists, we have court-connected mediated agreements or settlement agreements. Agreements that are reached in mediation can be processed from the mediation table to the court. And when it gets to the court, it can become a court judgment because it's a constant judgment. So there's a flow. When there's a connection, there's no frustration. When there's a connection, there's no division. So we are establishing the fact as we begin this discourse that ADR is not at variance with any known law within the legal space. There are several laws that we have stated much earlier that backs ADR. Permit me to state here that even in the Nigerian space, we have several multi-door court houses in Nigeria, and even within the High Court, several High Court civil procedural rules in the different states gives reference to alternative dispute resolution. The Lagos State Multi-Door Court House was established in the year 2002. It is reputed to be the first multi-door court house in Nigeria and in Africa. The Abuja Multi-Door Court House was established in 2007. The Edo State Multi-Door Court House was established in 2017. Several other multi-door court houses have been established. And what drives them? Their primary aim is to provide alternative dispute resolution services. And all these are court-connected ADR centers. That means they derive their powers from the courts. In the Lagos State High Court Civil Procedure Rules of 2019, Order 24 talks about mediation and conciliation. Order 25 talks about arbitration. In the Federal High Court Civil Procedure Rules of Order 16, Order 17, Order 18 are all ADR compliant. The Kano State High Court Civil Procedure Rules of 2017, Orders 18, Order 19 are all ADR compliant. The Abuja High Court Civil Procedure Rules of 2018, Order 14, Order 15 are all ADR compliant. The River State High Court Civil Procedure Rules 2017, Order 20, Order 21, Order 22 are all ADR compliant. Ogun State High Court Civil Procedure Rules 2016, Order 15, Order 16, Order 17 are all ADR compliant. The Edo State High Court Civil Procedure Rules 2018, Order 26, 27 are all ADR compliant. These are policies, these are rules that gives backing to the court-connected centers in each of these states to provide alternative dispute resolution services. You will agree with me, having stated all of the above, that we have a very strong legal framework for ADR. Permit me to add that Section 9D of the 1999 Constitution of the Federal Republic of Nigeria, as amended, provides for the settlement of dispute by arbitration, mediation, conciliation, negotiation, and adjudication. Now, can I make a step further by making us understand that Rule 15.3D of the Rules of Professional Conduct for Legal Practitioners in Nigeria mandate lawyers to attempt alternative dispute resolution before bringing any matter before the court for hearings. Now, this is so unique. This is very unique. Within the legal space, the rules for professional conduct, this is known to all lawyers. And what does it state? This is what it states. Rule 53D, in his representation of his client, the lawyer must not fail to inform his client about the option of alternative dispute resolution before resorting to or during litigation. Now, this rule underscores the lawyer's duty to inform the client. Now, lawyers must, as a matter of professional ethics, make their clients aware of the possibility of ADR as a viable option for resolving disputes. This implies that lawyers should assess whether ADR is suitable for the client's case or discuss the potential benefits from the drawbacks with them. I am fully aware that legal practitioners in Nigeria know this fact. Now, with all that have been said so far, it is glaring that we have strong legal framework for alternative dispute resolution. If you don't mind, I want to confirm if I'm still audible, and if you are still with me, please, I will appreciate if you drop some comment on the chat box. Comment that you are audible. Continue. We are together. It will encourage us to know that we are not just speaking to ourselves. I will appreciate if I have some comments on the chat box. Now, looking at Kaduna State, the Kaduna State Alternative Dispute Resolution Law 2013, we have the Customary Court of Appeal Rules, Kaduna State, the Sharia Court of Appeal Rules, Kaduna State, the law establishing customary court, district courts, and Sharia courts in Kaduna State, Section 23 of the law establishing customary court 2001. All these laws give validity to alternative dispute resolution. Having said so far, Section 56, sub 2 of the Sharia Court Civil Procedure Rules 2001, Kaduna State provides for the use of alternative dispute resolution in settling disputes as well as the sole rule. We are beginning to migrate from the legal framework into the religious framework. Now, I wish to confirm, looking at all the legal framework, all the laws that have been enumerated in the course of our discourse today, is it sufficiently and abundantly clear that within the Nigerian space, we have a very robust legal framework for alternative dispute resolution? If you support, please state it on the chat box. And if you are in denial, please state it on the chat box. But if you feel like making your comments, you want to speak to us, you can raise your virtual hands and I will grant you the floor. I want to be sure that we have been convinced, having quoted relevant and cited relevant laws, that we have a robust framework for alternative dispute resolution. Noble Lords, Your Excellency, thank you for your response on the chat box. Very robust as well effective. Thank you, sir. Zibel, Peter. I'll need more comments on the chat box affirming your position regarding the laws that have been discussed so far in relation to alternative dispute resolution. Have we been sufficiently informed about the laws? Thank you for your responses. Now we have two Supreme Court judgments, Owoshini versus Falalu and Aribisela versus Oguyemi. All these can be found in the Nigerian Weekly Law Report. These are Supreme Court judgments that validate alternative dispute resolution. Thank you, Hope Ekobari, for your response. Noble Lords, Your Excellencies, in the alternative dispute resolution space in Nigeria, it is evident that we have so many laws. Thank you, Adewumi Olakunle Atoni, for your response. Very robust and effective. I appreciate. All these give rise to alternative dispute resolution. So the part that you are about treading, the part that you have been introduced to, is a part that is legally backed as far as laws in Nigeria is concerned. Now, in this Supreme Court judgment above, it was clearly stated here a statute prescribes a legal line of action for the determination of an action, be it an administrative matter, chieftaincy matter, or a matter for taxation. The aggrieved party must exhaust all the remedies in that law before going to court. So we agree with me that the court dockets are very, very full. Thank you, TZ, Stephen, for your response. We agree that the court docket is full. Primarily, it is a well-known fact that whoever goes to court and at the end of the day returns from court may end up becoming an enemy for life with the other opponents. We live in a global village and there can be no progress when there's animosity. There can be no progress when we have unresolved differences. And that is why we now have the court-connected centers as multi-door courthouses and even private dispute resolution centers that are offering alternative dispute resolution services to disputants. Thank you so much for your response, Peace Polagy. I appreciate you. Noble Lords, Your Excellencies, thank you for your time thus far. Now, permit me to introduce the grand norm, the Arbitration and Mediation Act 2023. The act was signed into law on the 26th of May 2023, and it repeats the Arbitration and Conciliation Act. I'm fully aware that if not today, maybe some other time within this 1 week training, we'll be able to explore an overview of the Arbitration and Mediation Act. Moving forward, Kofi Annan once said, we may have different religion, different languages, different skin color, but we all belong to one human race. We all belong to one human race. And this means, despite our differences, despite our diversities, we are first human before we begin to divide ourselves along the line of religion. So beyond religion, we have something that brings us together. Noble Lords, Your Excellencies, highly esteemed virtual participants, permit me to progress into the religious framework for alternative dispute resolution. Religious framework for ADR often aims to provide a basis for resolving conflicts and disputes in ways that are aligned with the teachings, values, and principles of a particular religion. This framework seeks to promote harmony, reconciliation, and justice while taking into consideration the religious beliefs and norms of the parties involved. We have seen laws that gives legal backing to ADR. We are also of the opinion that there are laws that give religious backing to ADR. At this juncture, it will be of great value to this process if we can interface at this point. I should be aware that participants in this training are from different religious sects. So if you don't mind, in the next 5 to 10 minutes, it will be of great value if you volunteer. I need someone to volunteer. Tell us your name, tell us your religious sect, and educate us on your religious perspective as far as alternative disposition is concerned. Does your religion support amicable ways of resolving disputes? If yes, how? So the floor is yours. I hope participants are able to unmute. So please unmute and let us know your thought. You can raise your virtual hands and we can make progress. I hope I'm still audible. Hope you can hear me.
Yes.
Thank you. So who is taking the floor? We need to interact at this point. Introduce yourself, tell us your name, tell us your religion, and help us understand from your religion what your religion says about ADR. Does your religion promote violence? Does your religion promote peace? Does your religion promote coexistence? The floor is yours. Your time starts now. So who is taking the lead?
Can I?
Yes, please. Mr. Nimden, your floor is yours. You can make progress.
Yes. Well done, sir. Thank you. My name is Nimna Denden. I'm a Christian from Jos Plateau State. My religion recognizes peace, reconciliation, and the Bible teaches me that we should love my neighbor as myself. And one of the passages in the Bible is said, seek peace. If you have a problem with anybody, before you can even, before the person would even approach you, the best you can do is to try and meet him and settle for peace. And so peace is the key word in the Bible. Almost every chapter of the Bible, the issue of peace is very paramount. So when you're talking of peace, settlement, vis-a-vis settlement as well too. So I think alternative disposition is rooted in the Christian faith. Thank you.
Thank you so much, sir. So we have gotten one religious framework that supports ADR from the Christian perspective. Now, I will appreciate if we have two more comments. The floor is yours, please. Unmute and share your thoughts. Introduce yourself, tell us your location, your religion, and what your religion says about peace. Who is speaking? Who has the floor? Are we together? It would be great if we take one or two comments. Do we have any Muslim faithful in the house? All right, Stephen, please make progress. Mr. Stephen, you can unmute and share your thoughts. Okay, we have a response on the chat box. Okay. The Bible says that we should follow peace with all men. Also, the Bible says that blessed are the peacemakers, for they shall be called the sons of God. Thank you so much. I appreciate your response. My religion does not support violence in any way. Ebola, thank you for your response. We appreciate you. Do we have any Muslim in the house? Any Muslim participant? It will be great we hear from you. Right. At any point you feel like sharing with us, we'll be all ears. we talk about religious frameworks seek to promote harmony, reconciliation, and justice while taking into consideration the religious beliefs and norms of the parties involved, protection of their religious territory. Now, we've been able to hear one comment from the religious perspective. Now, let's make progress. What we were speaking much earlier, remember we introduced two guiding principles in Islam, the principles of Saul and Tahrim. Now, they are connected with conciliation and arbitration. Saul encourages parties to reach a compromise and settle disputes amicably. Tahrim involves the appointment of neutral arbitrators to make binding decisions based on Islamic law, which is Sharia. That means if there's a dispute among Muslims, both parties are Muslims, that dispute is being resolved according to the Islamic law. So the framework for the resolution of that dispute is the Islamic law. That Islamic law forms a basis for that dispute to be resolved. Thank you, Abu Bakr. Your comment goes towards the religion of Islam also encourage peace. In fact, the name Islam is derived from the root word salama, which means peace. Thank you, Abu Bakr, for educating us. So we have been educated today that the entirety of Muslims of Islam, taking into account the root word for Islam means salama, and that's been translated into English, it means peace. The process is to emphasize fairness, equity, and resolution of conflict without resorting to formal litigation. Quran 49, verse 9. The believers are a single brotherhood, so make peace and conciliation between two contending brothers, and fear Allah that ye may receive mercy. Also, if two parties among the believers fall into a quarrel, make peace between them with justice and fairness, for Allah loves those who are fair and just. The Sunnah of the Holy Prophet has it that the Prophet mediated a matter where he even asked a creditor to accept half of the payment if the debtor will pay him in full without installment. We are seeing this religious framework for mediation. Now, within the Jewish sect, there's what we call the Bet Din. Bet Din is a rabbinical court that offers mediation and mediation services for the resolution of disputes. Decisions in this court, in this rabbinical court, is based on the Jewish law, the halakha. All that governs the actions, their code of conduct is based on their laws. So within every religious sect, there are religious laws that dictate how disputes will be resolved. 1 and 2, in furtherance upholding the values of each religion. Now, we've been able to establish that within the religious sector known as Christianity, it encourages dialogue, active listening, forgiveness, and the goal of preserving relationship and promoting healing. Matthew chapter 5, verse 9. Blessed are the peacemakers, for they shall be called the children of God. Romans 8:18. Romans 12:18. Do your part to live in peace with everyone as much as possible. Proverbs 25:8. Don't be in a hurry to go to court. You might go down before your neighbors in shame. All these, beyond the fact that these are scriptures, they form laws that guides the norm of Christians, individuals within this religious sect, and determining how they are to resolve their dispute. We all know that in 1 Corinthians 13:4, within the religious sect, speaks about love. Love is patient, love is kind, love does not envy, love does not boast, love is not conceited. Now, within the Buddhism, although it is not formalized, But there's a Buddhist principle that is known as metta, loving kindness. This principle emphasizes understanding, empathy, and non-harming, which can guide parties towards a non-adversarial resolution. This is also inclined towards alternative dispute resolution. In Hinduism, emphasis is on Dharma, which is interpreted righteousness. Holistically speaking, it is the pursuit of harmony among the religious faithful. Now, the mediation and negotiation techniques rooted in Hindu values of non-violence, truth, and self-control may be used in addressing conflict. Please, I would love response on the chat box to confirm that we are still very much together. So we've been able to look at some religious sects and laws, values, scriptures within them that upholds peace, that oppose alternative dispute resolution. It is important to note at this juncture that this religious area framework can vary widely from religious sect to religious sect. But the basis is that it approaches dispute with sensitivity and respect for the beliefs and practice of the parties involved. While making an attempt to resolve the disputants, it also goes ahead to uphold the values and what the religious represents. Thank you for your responses on the chat box. It is encouraging. I'm glad that we are together, and I'm glad that I'm still audible. In many cases, this framework are used alongside secular ADR method to provide a holistic and cultural sensitive approach to conflict resolution. Your Excellencies, noble lords, it is my delight to inform you that within the last few minutes, we've been able to look at the legal framework and some religious framework that guides alternative dispute resolution, that supports alternative dispute resolution. And the aim of this session is to equip you with basic information to the fact that you can speak to audience, speak to individuals from legal perspective, from religious perspective, that ADR is being accepted by both the law in our legal framework and in different religions. I appreciate your time. I do not take your time for granted. At this juncture, you can entertain one or two questions, comment, remark, or if there's anything you feel like adding to what has been said. No one has monopoly of knowledge. The floor is yours. Do well to make your response at this time. Thank you for listening. You are free to ask any question, make any comment or contribution. Thank you, Rene, for your response on the chat box. Thank you for your attention. I appreciate your response. Do we have any other comments or question? Thank you, Dedin. I appreciate your response on the chat box. Mr. Nachan. Thank you, Maren Solomon,
Yes,
for your response. I deeply appreciate.
Hello, sir.
Thank you, Bolaji. Mr. Nachan, over to you to preside from here as the chief priest of this training. Thank you. I appreciate it.
All right, thank you very much for that wonderful aspect. Legal and religious framework. New question. I think Ambassador Samuel, you can excuse yourself when necessary, so that I can
appreciate you, sir.
Thank you very much. Do we have questions? Do we have questions? Do we have questions? Hello, can you hear me? Can you hear me? Hello? Please, can you put on your your audio and let me hear what you are saying? Can you hear me? Hello, can you hear me? Hello, can you hear me? I want to hear you speak. Can you hear me?
Okay, we can hear you, sir. But the issue before was that we were not
Okay.
allowed
I
to
can see
unmute.
that we are muted. Okay. Can you hear me now?
Yes, sir.
Okay. To avoid situation where people um
Yes, we can hear you now.
their mic can just be open
Yes, we can, sir.
just like that. That's where we put it on mute so that everybody, before you can speak, you have to be given permission. So thank you very much. I can see. Okay, do we have any question about the legal and religious framework? before we go for a break? Do we have any question?
So there's a question posted on the chat, sir.
Okay. At what point does one take into consideration the religion of the parties in the course of mediation? Okay, Bolaji. Is Mr. Samuel here? Okay. Now, do we have any other person who wants to ask a question? I will attend to this. Do we have any questions? Okay, Comfort.
Yes, sir. So mine is a
I can hear you.
because I was having a lot of distractions on my end. So I don't know how soon we can have maybe a recorded version of it to listen to because I missed a large portion of the train.
Can you say that again?
I said from my end, I was having a lot of distractions, both with network and the task that I was into. And so I missed a lot from today's tutorial. And I don't know how fast I can get the recorded version to listen to, sir.
Well, we encourage everybody to take to be in present attendance, but if for any reason you miss any part of it, we can send you a part of the part that you miss so that you can update your knowledge. Okay, so in the absence of any question, let's attempt this one, then we'll go for a break and then we'll come back. At what point does one take into consideration the religion of the parties? You see, as a mediator, religion is very crucial. You see, if you are having a Christian and a Muslim in a dispute, you know that the two of them have different understanding and beliefs. So right from the onset, if you have parties before you, you need to know the nature of the dispute. Is it business? Is it religious? In fact, we have Islamic mediation. We have people who may say they are Christians and they want to use biblical principles in resolving their disputes. Are we together? Are we together?
Yes.
So if it is let's say it's a sharing of inheritance under Islamic law and there is a dispute, you can resolve it through Islamic mediation. And you have people who are experts and specialists in that field. Mind you that if you are a professional, you can actually help people in your area of specialization. So if you are a professional in Islamic law, you can become an expert in Islamic mediation because you have the know-how. the necessary skills and the know-how to be able to do the needful. On the other hand, if you have a Muslim and a Christian, you have to be very sensitive. In fact, even among Christians, like in the Hadiza, are you with me?
Yes, I am with you, sir.
Can you tell us something about the Islamic sects? I believe that there are different sects in Islam, right?
Yes, they are, sir. I think, for example, in Nigeria, we have the Sunnas, we have the Shiites, and one more, sir. I've forgotten the name, sorry. They are not that big and much, but it's basically the same Islam, just some people decide to take some part of it more into consideration when practicing Islam than the other part. Like for the Sunnahs, we take the Sunnah of the Prophet Muhammad sallallahu alaihi wasallam into our daily practice. I think that is what really just differentiates us.
Okay. So you see, if you are a mediator, let's say you are not a Muslim, and you have two Muslims before you. They are both Muslims, but they are beliefs. If there is a way you can find out, okay, which sect do you belong to? So it means that you have to be vast and knowledgeable about the field. That's the sect that they belong to. Are we together?
Yes.
Are we together?
Yes.
So because
Yes,
there are things they believe in, there are things they work with. If you, in the course of mediation, go and say something contrary to what they believe, you may jeopardize the mediation, right? So that's why we're advocating for people who possess subject matter expertise. We're looking for people with subject matter expertise so that they can be appointed. You are a medical doctor, who assign medical related dispute to you. You specialize in medical related disputes. So if you have Muslims, you need to know which sect they belong to and what they believe. And as during our induction, the Leonard Silk, the former president of the Institute of Chartered Mediators and Conciliators, state clearly that it is not every mediation that you need to accept appointment. If they say, oh, Mr. Nimnan, you are appointed as a mediator, then you just accept. And you look at the subject matter, these are Muslims, the subject matter, you are not conversant with it. Yes, you are knowledgeable as a mediator, but you don't have subject matter expertise in that field. Except if it is maybe a Muslim and a Muslim, they are engaged in a business transaction, and it is not strictly the application of Islamic law, then you can mediate. But where it is related to Islamic law, can you get somebody who is more conversant with the subject matter? That's for Muslims. So right from time, you need to take note of people's religion. If it is somebody that does not believe in God, and the other one believes in God, by the time you start making comments that suggest that you also believe in God, the person will not be comfortable. There is no way he will be comfortable that you have two people who believe in God and he does not believe in God, and that is going to get justice on the table. You will not. So once you know that one does not believe in God and one believes in God, the religion right from time becomes very, very crucial. You consider it, and there are certain things you need to avoid. Now, among the Christians, you have the Pentecostals, you have the Protestants, you have the Catholics, among others. These are all said to be Christians, but they have their own beliefs. So you need to consider the belief of these people. Like Catholics, you have a Catholic and there are areas in which there are some things that the Catholics believe, and there are others that some of the Christians also believe, or there are areas where they don't believe, all of those things. So by the time you are a mediator and then you are mediating between Christians and you assume that you are Christian and you begin to say certain things without knowing the religion and the sect in which these Christians are before you belong to and what they believe. Knowing what they believe will actually guide your activities, will guide you on how to navigate around, knowing fully well that your purpose of discussion or your purpose there is to facilitate communication, not to become an obstacle. Please, Bolaji, I hope you understood.
Yes, thank you.
Good. So, and also where the religion dictates of the parties are in conflict with the law, how do we resolve that in the course of mediation? You're an expert. Your expertise will help you to navigate. When you know certain positions, that's why you have provisions like caucusing. That caucusing will give you the opportunity to be able to ask difficult questions, to examine certain things, to do reality testing and all those things. Some of those beliefs you are going to have opportunity to discuss, and the person will not see it or take it personal with you. And so that's basically about that. So Yilikachi said, does that mean that in mediation, religion of the party is very crucial regardless of the subject matter? Yes, so do you know that it is our belief and our faith that actually dictates almost most of the things that we do? As a Christian, you don't just keep your Christianity aside when you are into business. So also as a Muslim, you will not put your religion aside when you are into business. So the vision of Settlement House, we say we want a situation where we will help people to be able to adopt ADR, alternative or appropriate dispute resolution, as the best way of resolving dispute for life, for business, and for faith. In your life, generally, in businesses, and in faith. That's the vision. So yes, religion is very, very crucial and is very, very important. Very, very important. Now, having said so, I think this is a comfortable place for us to take a break. Are we together?
Yes, sir.
So I want to take a break for
Excuse me, sir, please, may I ask a question before we take the break? Just going to be
okay.
straight for a short.
Go ahead.
Yes. Sir, okay. Thank you.
I didn't get what you said. Can you type what you are saying on the chat box, because your voice is cracking? Type your question on the chat box.
In the case of ADR,
Adiza, can you hear me?
For example,
Adiza, can you hear me? Adiza, can you hear me? Adisa, can you hear me? Okay. Adisa has a network issue. She wanted to ask a question, but maybe when she comes back, she'll be able to ask her question. Okay, so we want to take a break and come back at 1:35. Is that okay?
Okay.
Yeah, so
Or is that break not short? It's already one.
It's sure to.
okay, so we should come back at 1:40.
Yeah.
Is that okay?
Okay.
1:40.
It's okay. We are thinking 2 o'clock, but it's okay.
Please, let's try. We are all
It's
doing
okay.
it for your benefit. We have a lot we need to pass across, but we'll ensure that if we wish that you can just sit down so that you take all the things that we have for you. But since it's necessary to take a little break, please, let's just manage us for now. Let's come back at 1:20, 1:40.
That's okay. Thank you.
All right. So you can stay on if you log out, so, but you can stay on if you so wish. But please, let's try and return as quick as we can. We can return as quick as we can. Thank you. This is break time. We are returning by 1:40. In case you are just coming in, we are on break. Those were our graduates that were inducted yesterday. We're on break. We just have a few minutes to be back. Now here are some of the participants, inductees that were inducted yesterday from Settlement House Area Training Institute. All right. Thank you. Thank you. Thank you. We're supposed to be back by now. Okay, you can tell your friends to come back in. Please tell your friends to come back in. Tell your friends to come back in. So I think the others have gone to eat some pepper soup and amala ewedu. So I think we can proceed, isn't it?
All
Hello?
right. So,
So we proceed or give maybe 2-3 minutes.
2-3 minutes, sir.
Okay, it's as if you are eating a amala. That's why. Congratulations to our newly inducted associate members of Settlement House Area Training Institute, certified mediators, brand new from Shati. We wish all yourself the best, that everyone will get to this point where you will be inducted as an associate of Settlement House Area Training Institute and be entitled to use the title is Shati after his or her name. Okay, welcome back, all participants from your brief break. You end up taking the time that you wanted. You know, we wanted to utilize the time to please, can you hear me?
Yes, we can.
Okay, thank you very much. All right, so we are going to go straight. Okay, so now we're on our timetable. We are supposed to go through the new law. We have looked at legal and religious. So one of the interesting and most recent acts acts that we have, Mediation Act. And we are going to be looking at some Hello, can you hear me?
Yes, we can hear now.
Okay. So we are going to be looking at an overview of the Arbitration and Mediation Act. And by an overview, this is the first time we are having a law that actually prescribes mediation. Initially, we do not have a national law that makes provision for mediation. But now, to the glory of God, we are now having a law that talks about mediation. It's very, very exciting. It is important that you have an overview of what it is, especially as it relates to mediation. So, can you see my screen?
Yes.
Yes.
All right, thank you. Now, the law we have before is the Arbitration and Mediation Act of 2004. Okay, so some area practitioners have been okay. Can you confirm if you can hear me and if you can see my screen? I also alternate to the other network.
We can hear you and see the screen, sir.
It's only now that we're hearing and seeing the screen package.
Okay.
Now is clear.
Okay, so now in Nigeria we have the arbitration and mediation, and by the preamble, it clearly says that this act repeals the Arbitration and Conciliation Act that was contained in Cap A18 of the Laws of the Federation of Nigeria 2004, and it enacts the Arbitration and Mediation Act 2023 to provide a unified legal framework for the fair for the fair and efficient settlement of commercial disputes by arbitration and mediation, and to make applicable the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which is referred to as the New York Convention, to any award made in Nigeria or in any contracting state aside from the fact that before that the New York Convention, which Nigeria has not ratified. So, and then the New York Convention makes provision for the enforcement of arbitration award, and then all those other things that connect to arbitration. So when there is an international commercial arbitration that is an award was delivered from any part of the world, it can be enforced in the country which is a signatory to the New York Convention, and that has been domesticated in the particular country. So here we are with this new act. It has adopted, in fact, the Singapore Convention as well as the New York Convention. New York Convention is on arbitration. The Singapore Convention is on mediation, international settlement disputes, So international settlement arising from mediation are all accommodated by this law. So that makes it a very viable tool that we can use for everything that we need. Now, I'm going to concentrate basically on the aspect that has to do with mediation. And as you can see, under the part 2 of the arbitration and mediation, we are doing this so that as mediators, you will not become novice, you will not be unaware of the laws that regulate some of the things that we do. One of the arguments against mediation as at then was that it is not enforceable, it is not binding. But you can see the scope of the application of this act, uniformity of the interpretation, variation by agreement, commencement of mediation proceedings, suspension of limitation period, number and appointment of mediators, the conduct of mediation, the fees and the expenses, so that you know that you are entitled to all of these things and you know what needs to be done. The issue of disclosure, confidentiality, admissibility of evidence in other proceedings, termination of mediation proceedings, mediator acting as arbitrator, resort to arbitral or judicial proceedings, immunity for mediators and mediation providers, binding and enforceable nature of settlement agreements. Please, if you know anyone that ought to be here and is not, please reach out to him or her. Let them join, please. So these are the provision requirements for reliance on settlement agreement, grounds for refusing to grant relief, parallel application or claims, general principles and application. I'm going to just highlight so that you just see. We may not have time to discuss the whole of these things, but at least these are the provisions that are made in the national law that pertains to mediation. So we will just go to the aspect that has to do with mediation. These are the provisions. If you have time, we are going to send a copy to you on the platform, the training platform, and you have a copy of all of this. Okay, so the section that has to do with arbitration is contained, as you can see from part 2, section 67, from 67, section 67. That's what the aspect that has to do with mediation. So here we go. Okay, so the section from section 67 of AMA, you see the provision that has to do with mediation here. Can you confirm if you can all see? Can we all see?
Yes.
All right.
Yes,
Now,
sir.
okay. Okay. So, I want to confirm. Okay. All right. So look at this. Section 67, the scope of the application. The scope of the application. All right. So look at this. Now, you see, the under the scope, this part of the mediation, it applies to international commercial mediation, one. Number two, domestic commercial mediation. Three, domestic civil mediation. Four, domestic and international settlement agreements that are resulting from mediation and concluded in writing by parties to resolve a commercial dispute. E, where the parties agree in writing that this part should apply to them. So if you are looking at those that this part, this law is going to be applicable to them, number one is going to be international commercial mediation. International commercial mediation has to do with the mediation where you have parties, the parties involved are from different countries. Or that they, just like the issue of jurisdiction, when you are determining jurisdiction, you know, you are in law, you are looking at I don't know whether you can hear and see me. Can you hear and see me?
Yes.
Okay, that's good. So now this this part of the arbitration and mediation is applicable to international commercial mediation. It is international where the parties are from different countries, or the subject matter, or where they intend to enforce whatsoever they are doing is in a different country. Let's say Nigeria and Ghana. There's a mediation between the company there or an individual there and that of someone here. That makes it a commercial, international commercial arbitration. And domestic commercial arbitration, commercial activities. So because there are some things that are not mediated, you cannot mediate, which we have mentioned in the introduction. Domestic has to do with within Nigeria, agreements reached, mediation, commercial mediation that are conducted within Nigeria. This act is applicable. Then domestic civil litigation. Aside from commercial transaction, you can have a husband and a wife, they have a dispute, and then the husband is not talking to the wife, and then the matter gets to court, and then they can sit down and discuss. These are civil matters. They are not commercial in nature. I hope we are together. We are understanding me. I hope you are understanding me.
Yes, sir.
Yes, sir.
All right, good. Now, whether it is international or whether it is domestic or it's international, settlement agreement that came about as a result of mediation, and the parties, it is concluded in writing by the parties that they are going to resolve through mediation. So whether it is an international here in Nigeria or it is involving different countries, as long as the parties agree that they are going to resolve that dispute, if dispute arose, they will resolve through mediation. It means that this part is applicable. That's scope. Now, if parties by their own agreement they decide that mediation is going to be applicable, then this act will be applicable. That's a part. And the dispute that can be resolved via mediation the dispute that can be resolved via mediation includes the dispute that are emerging from right and obligation settlement, which could be void under. Now, okay, we have looked at the scope. Now, this act will not apply where, for example, we have provisions of laws. Like we have lawyers here. I don't know whether somebody could volunteer to give us an example of a dispute where involves rights and obligation. And I would say these are usually excluded from mediation because you may need the court to decide it. Will anybody want to attempt?
Yes.
Okay, go ahead.
Okay. There are some criminal cases that you cannot do mediation over same, especially if it is, you have to understand compoundable or non-compoundable offenses. So
yeah.
there are those that are agreed, simple offenses that the court can agree from, but there are some that the court will not, the law will not allow you to settle them.
Okay.
Okay, sir. Can I add, sir?
This part, yes.
For capital offenses under criminal litigation are also not open for mediation, like rape, like a robbery, and some of those offenses that come with a term of either life imprisonment and thereabout.
Somebody was speaking before. Someone was speaking. Okay, capital offenses, yes. Any settlement that you are going to do that is going to be void under Nigerian law, that is, this section of the law is not applicable. Please take note. It's not applicable. Then cases that a judge or an arbitrator has attempted to facilitate the settlement, and maybe the settlement fails, that this section will not be applicable to it unless if the parties decide otherwise. Please take note. Then cases where, in instances where parties have already undergone arbitration and award has been given and enforced, there is already an award and that award is enforceable, then this part will not be applicable. But remember, at each point in time, they are saying unless the parties agree otherwise. So the parties have the power to do and undo. It is their right. Cases have been concluded by a court of law or is in the process, is before a court, cases that have been approved by a court or concluded in the course of proceedings before a court. This session will not be applicable. Those matters are concluded. Then cases that are enforceable as a judgment of a court in this country, this part of the law, mediation will not be applicable. Please, you need to take note of that and take it very, very seriously. Okay, so that's a minute. Okay. Okay. So also okay. All right, so the second one is that it's talking about uniformity of interpretation. And when you talk about uniformity, now this Arbitration and Integration Act is applicable in the whole of Nigeria. And aside from Nigeria, it's also applicable to international commercial arbitration and mediation. So you see that international companies, organizations, investment companies will not find it difficult again coming to Nigeria, knowing that we have adopted the Singapore Convention on settlement of disputes, and we have adopted the Singapore Convention that has to do with arbitration and its enforcement in countries that are signatory to and have domesticated the law, in their own country. So you see, that is it. So this is a very, very important aspect that you need to take note of. There is uniformity. Now, how do you commence mediation? Under section 69, you say, except the provision of the section 72 sub 3 of this act, the parties may agree to exclude or vary any of the provision of part 2. Now you see, those part 2, is stated what and what needs to be done. Now, this law is telling us that the parties have the right to vary it. Irrespective of the fact that they said this and this is not applicable, if the parties come and say, this, we want it to apply here, Fine and good. Assuming they say 1 day is given to do something, and the parties by agreement, they say they are going to do it within 2 or 3 days, that will also be fine. Are we together? Are we together, please?
Yes.
Yes, sir.
Yes,
Now,
sir.
yes. How do you commence a mediation proceeding? How do you commence? You commence a mediation proceeding under this law as prescribed by any special statute as a condition for the conduct of judicial or otherwise other proceedings, or where the parties have agreed when concluding the agreement to try to resolve the dispute through mediation before resorting to judicial or other proceedings. The party concerned shall propose to the other party in writing the conclusion of a mediation agreement. Now you see, where there is an agreement to mediate, generally parties have the right to resort to the court where they feel that their rights have been infringed upon or there is a dispute. But the parties can decide to limit their rights to approach the court of law by inserting what is called the dispute resolution clause. That dispute resolution clause will provide specifically whether the dispute will be resolved through mediation, or it will be resolved through arbitration, or it will be resolved through negotiation. So if that is done, if there is a provision of that nature, it therefore means that where the dispute arises, the parties will not go to court. They will ensure that they explore mediation. And where the dispute arose, what you do is you communicate to the other party in writing that you are going to take up and start all the mediation. Communicate to the other party. And where a party that invited the other party to mediate does not receive an acceptance of the invitation within 30 days from the day on which the invitation was sent, or within any other time as specified in the invitation, the party may elect to treat this as a rejection of the invitation to mediate. Now you see, unlike arbitration or the court where you have the power to enforce somebody to go into you can compel the attendance of a party. Where you want to initiate a mediation and you send a letter or invitation to the other party and the party refuses to respond, there is nothing you can do about it. You cannot force the person. You can only treat that rejection. You can treat that refusal to attend as a rejection of the invitation to mediate, and you may take other legal actions, which may involve going to court. At least you have fulfilled your own part. You are taking a step to resolve by your agreement, mediation, and the other party has refused to acknowledge. So a party can now decide to propose that they should settle via mediation, regardless of any other judicial or arbitral proceedings before, during, or after the initiation of the judicial proceedings. This is one thing that you must take note of. Before the dispute arises, you can decide to say you resort through mediation. When the dispute arose and you have even filed a matter in court, you can decide to opt for. That's if you have not stated clearly in your agreement that you are going to resort through mediation, arbitration, and the dispute has arisen and you are in court. This authorizes you to go for mediation or to arbitration. So they said, regardless of all the other judicial or arbitral proceedings, before, during, or after the initiation of a judicial proceedings. So you can have recourse to mediation or arbitration even after, if the matter is already in court. That's one thing you should take. These are the provisions of the law. Please take note of them. So during any arbitral or judicial or administrative or other proceedings, the body conducting the proceedings may recommend to the parties to resolve their dispute in mediation proceedings in accordance with the provision of this part, where it assesses that there exists the possibility of resolving the dispute by mediation. Your worship, Nahid, I don't know if she's still with us.
Yes, I am, sir.
Perfect. Now you see, this is a law that is empowering you. I don't know whether we have other sitting magistrates or judges. This law empowers you that if there is a matter going on before you and you assess that that matter can be resolved and settled via mediation, you can recommend it to the parties. This is one beautiful thing about the law. That's why we say let's give an overview so that you have an idea. This is under section 70 of 4. You know, you have the power to recommend it, notwithstanding whether it is a matter is before an arbitral tribunal, whether it is before an administrative authority, whether in school or universities, whether it is before the court of law. In fact, all the court of law, including High Court, we have multi-door courthouse. In the National Industrial Court, we have ADR Center. In the Court of Appeal, we have ADR Center. At the Supreme Court, we also have ADR Centers. So you can see, you have the power to do so. So if the
But
judge,
the parties have to be willing, right, to comply.
you can send them. You can send them. Just send them first. Some of them don't know what it means. Some of them, their lawyers have told them that they should not agree to anything settlement. Some of them, but they don't really know what it entails. There is nobody that you send to a process. You ask to go for a process where he has the power to decide his fate by himself. And he will say he does not like or he does not want. Whether they like it or not, if you feel you have a discretion, you have discretionary powers, your worship, you will say, okay, I am referring you, you have the multi-door courthouse. In fact, I've had instances where some magistrate referred matter directly to me. They say, okay, this matter I feel you can settle. I have someone who can help you resolve your dispute. And then I've settled some of them, you know, in fact, within 1-2 hours, we are done. So once you know that this matter can be resolved, you have the power to recommend, you know, they said you have the power, according to the provision of this law, if it assesses that it exists the possibility of resolving the dispute. So you may recommend to the parties to resolve their disputes through. So sometimes the parties don't really know. And sometimes when you decide to recommend them and you bank on this law, they cannot go and explore that process. Some of them will get attracted to it. Some of them will say, oh, so there is something that exists like this. Some of them don't know. And that's why we want lawyers to get trained in this process. When you have charged your client and you go for mediation, when you are able to settle, fine and good, you collect your fees and what is due to you. And instead of wasting, I had the privilege of representing a bank in a matter where a client is saying that they've debited money from his account unlawfully without authorization. The matter was in the High Court. I happen to be the lawyer, and then I am a mediator. So they did not assign the matter to me, but they assigned to someone else. So the position of the bank is that they don't deduct money from clients. So, but because the matter was referred by the judge of the High Court judge, it was referred to mediation. They had to take it to the multi-door courthouse, and it was during the settlement week. They called the parties. When they see that the judge has sent you to that place, most times the parties will try to comply, to do their best, so that by the time they come back and they discover that there is a report that this person was the one that frustrated or did not attend, you know, it has a way of working on the mind of the judge to know who is actually wearing it. So they sent us to the multi-door courthouse. Eventually, I was like, bank, you know, the days, you know, so bad. You know, they did the session like play. Before you know it, we connected to the legal department and said, okay, they have sent this matter to mediation, or we need a representative and all of those things. They discussed at the end of it. The person was saying that if only they can help recover his refund the money that was debited from his account, he will forgo some of the claims and all of those things that he made. So the bank now say, okay, they are not claiming, they are not accepting any liability, but because in the spirit of settlement, they will be willing to pay him back his money, but it is not as if they have deducted any money from his account, but in the spirit of settlement. Now, nobody will ever think that that matter can be resolved and settled at all, because the bank will actually prefer to defend their matter to the Supreme Court than to give an opportunity for somebody to begin to see that if money is deducted from your account, that it is the bank that deducted it. So these are some of the things that, first of all, explore the procedure, recommend and send it. You have the power to do so. Send them to where they can go and explore settlement. Now, if you say go and settle by themselves, if you know that the lawyers or their representatives are area practitioners, they can easily do that. But if you know it is just lawyer, send them to the multi-door courthouse, for example, and they can go there, follow the procedure. If they fail, they can come back at any time. If this process is failed, you have the option of returning back to court, but let them have the benefit. I hope we are together.
Yes, sir.
Okay, thank you very much.
Yes, sir.
Now, the day once you have commenced, the other party has responded. I told you that when you come before the mediator, that is what is called agreement to mediate. The commencement of arbitration is when the parties have signed that agreement to mediate. That is when the matter is properly commenced. So take note. The mediation has commenced when the parties sign that agreement to mediate. Now, suspension of litigation period. When the mediation process commences, the running of the limitation period regarding the claim that is the subject matter of the mediation is suspended. This applies to matters that they have time within which for you to file or do something. So sometimes parties may be playing their tricks. They will just come and be doing like this, so that time will elapse. If it is 2 months and you file a matter in court, and in the court they say you should go for mediation, now, and then the 2 months that is provided elapse, the time you spend during the mediation is not included in the computation of time. Are we together?
Yes.
Yes, sir.
Yeah. All right, so please, you need to take note of that. So now, when it comes to appointment of mediator, things otherwise, unless of the mediators shall only be so when it comes to house, they will have panel of neutrals, and those panel of you are going to bring the list of the panel of neutrals. The parties will now choose the person they feel is suitable. But when appointment, one person is enough. But if you have two mediators, you pay two mediators, fine and good. That is for them to decide. Now, the parties are in the vote to reach an agreement on a mediator or mediators unless agreed upon. Sometimes you can say the executive director or settlement of the governing body or settlement house should be the one to appoint a mediator, or the institute should just appoint a mediator. If in your argument it is the president that will appoint a mediator, fine and good. If not, the parties themselves will be the ones to decide, and they have to agree on who is going to do that and be the. Now, a party may the settlement house to be the one to appoint your mediator, or you want assistance. You want to do a mediation, but you want maybe certified mediators from settlement house, so you can appoint us. We are mediation providers. So provide an opportunity for practice. So that we can choose from among them, or help us to choose. If you want to choose by yourself, if you go to our website, you see the list of our mediators. Mr. Law, you are welcome, sir. All right. So, we now have, if you want the assistance of a mediation provider, the mediation provider can make recommendation as to suitable candidates, because they are into the field and they know if your dispute is in construction. Mr. Lloyd, you are welcome, sir.
Good morning. Good morning. Good morning for me. Good afternoon for you.
Yeah, good morning. It's actually evening over here, but I know that in Florida, that will be what time is it over there, sir?
It's almost 10 o'clock, 9:50 our time.
Session, please.
You were breaking up. I didn't know if you were talking to me or talking to the students.
Yes. I'm saying that I'm about to round up this session so that you can proceed with yours at 3.
Yeah, I logged in early, so you take your time. Take as much time as you need.
Thank you very much. Thank you.
You're welcome.
All right. That's our next speaker. He's already here with us. Thank you very much for joining us. So now, under Section 72 of the Arbitration and Mediation Act, it says it's talking about the appointment of mediators. And when you are appointing a mediator, you can agree by yourself, except if you have made a provision for how you want to appoint. I gave you an example. You can decide that it is an institution, or your pastor, or your reverend, or your imam that should appoint a mediator for you. If you have agreed on that, that is fine. But where you have not agreed, it is the parties that will decide. And in deciding who the mediator shall be, the parties can decide to seek for the assistance of a a mediation provider, and I say Settlement House ADR Training Institute, Shati is a mediation provider. We do training and certification. We also provide avenue for practice and mediation or arbitration. So we have arbitrators, we have mediators. So if you say, please, you have a list of panel of neutrals, can you give us the list so that we choose for ourselves? You can also decide to seek the assistance of, okay, you can say, please, you are conversant with those who have specialty in the field. You have construction dispute, for example, and then you know who has expertise in construction dispute. So please, can you appoint for us? You can say the chairman of the governing body should appoint. You can say the executive director of Shati should appoint. You can say the institute itself should just appoint anybody. So, but if you have not done all of this, it is the parties themselves that will have to do the appointment. So now, if you have set a standard, the mediation provider will say, we will have to comply with what you have agreed on. Let's say, for example, you say you want a lawyer who has experience of about 15 years and has expertise in construction-related dispute. The mediation provider will have to assist you to see that they meet up with that standard. Where they do not have someone with that qualification and standard, they can reach out to you and say, please, we do not have someone who meets up to your qualification, except if you people agree to alter the qualification. So that's what this section is talking about. Now, where you have been appointed, it has been mentioned before, if you are to be appointed, you must ensure that you make proper disclosure. Disclosure has to do with issues that can create doubt as to your impartiality and independence. It's very, very important under subsection 5. That is what you should consider. So before you accept, you must ensure that you don't have anything that can create doubt. And in case if there is, one of the parties is your friend or your business partner or is related to somebody, raise it to the parties and say, this person, I know him as a business partner, I've done this and this, are you okay for me to proceed? If they say yes, go ahead, fine. But if they say they are not comfortable, then you have to look out, you have to reject that appointment. In fact, it is not every appointment as a mediator that you must accept. That's very, very important. You need to take note of that. Now, so as to the conduct of the mediation, the fees and the rest. Now, here is it. You are entitled to a fee, except if you are doing a pro bono service. If you are appointed as a mediator, the parties will have to agree as to the fee. If it is an institution, the institution may have their own fee schedule. So if you say Settlement House is going to be the one to administer it, based on our rules and regulations, we have schedule of fees, and they will say that schedule automatically become applicable. That's if it is an institutional mediation. But if it is an ad hoc mediation, you can just approach an individual who is a mediator and say, please mediate for us. And then with that, you are going to agree as to the fee. You are going to discuss the fee with that mediator. So that is what is obtainable here. Now, as to the duties of the mediator under section 73 sub 4, it said the mediator shall promote communication between the parties, and then he shall ensure that the parties are integrated into the mediation process in an appropriate and fair manner. That is the duties and responsibility of the mediator. Now, this is one interesting provision also. The parties can decide that, this is electronic means. They will decide to say they want do their mediation through electronic means. They want to mediation session via Zoom. In that case, you do it via electronic apps that will make you do what you are supposed to do. That avenue you want to use, has to ensure it has to be in such a way that transmission of voice or image are very clear, just as the way we are doing now. You can see that you can interact with someone really and get to know the person. In fact, you may be broken into groups where you do face-to-face interaction. It's as good as having a physical training. It's just that you cannot touch the person, but you get to interact with the person, you see the person, you do whatsoever you want to do with the person, you see. So easy. Everything depends on the parties' agreement. So take note. They say the mediator may. He may. The mediator may. The power to impose, but he has the power to make proposals to settlement. Very, very important. He can make proposal, but that proposal is subject over, accommodation. All those can you hear me? Please, can you hear me?
It's only now we're hearing, but it.
Okay. So the mediator is entitled to his fee. So and the fee is going to be agreed by the parties and is usually shared. The fee and expenses of the mediation as well as the fees of the mediation provider shall be borne by the parties in equal share. This is clearly stated by the law. So if the fee is 10 naira, if it is the mediation provider, let's say settlement house that is taking care of the training, they are going to pay them. If it's an individual mediator, he is also entitled to his fee. If his fee is 10 naira, it's going to be shared between the two parties. Party A will pay 50, party B will pay 50. So if there are expenses for the training, the expenses will also be borne by parties in equal share. But instances where you have interest and then the other party cannot pay, if you decide to pay, there is nothing wrong with it as well. So the communication between the mediators and the parties, communication between the mediator and the party, in the course of settlement, you may have need to do a caucus. They mentioned the issue of caucusing. You may have a personal, you may have a meeting with the parties in a joint session, or you can have a meeting with them separately as the mediators considers necessary. That's what we refer to as caucusing. So take note, it's very, very important. the issue of having personal meeting before some lawyers will say, no, you cannot have a meeting with my client. It's clearly stated in the law that you have the power as a mediator to meet with the parties separately where necessary. So it is at your discretion. When it comes to the issue of disclosure of information, you know that you have the power, mediation is confidential. So you are not going to share the information that you discuss during caucusing with the other party unless he gives you the permission. You say, oh, this thing you are telling me, is it okay if I share with the other party? You say, no, I don't want you to share. No, you can share, there's no problem. You have to take permission. So where the mediation receives information concerning the dispute from a party, the mediator may disclose the substance of that information to any other party to the mediation. But when the party gives any information to the mediator, subject to a specific condition that it may be kept confidential, that information may not be disclosed to any other party. That's what we are saying. Assume after a discussion, you say it's a mediation session, then you now go and begin to share the information you receive with the other party. No. After the caucusing, after the personal meeting with the party, ask whether you should be allowed to discuss it with the other party. And if he says yes, then you can go ahead. Now, unless otherwise agreed to by the parties, all the information relating to mediation proceedings shall be kept confidential, except everything is confidential except if it is disclosed, except if disclosure is mandated by the law. Everything you are doing is confidential. You will not tell anybody. If the parties, the mediator, everybody will keep it confidential unless if the law so specifically required it, or for the purpose of implementing or enforcement of settlement agreement. You cannot say the agreement is enforceable and then one party has failed to comply. Then you say, if I take that agreement to the court for the purpose of being adopted as a consent judgment or for the purpose of enforcement, and say, no, you have breached confidentiality. No. Except for the purpose of implementation or enforcement, you can disclose it to a third party and not everybody anyway. People in the court will have access because you want to. Where it is necessary in the interest of I've had, when it is for the purpose of the commission of a somebody said that I'm going to kill this person when I leave this place, then it is on you as a mediator to ensure that you disclose that information, because you say, I am bound by confidentiality and the person is going to kill another person. If it is like this also person and police are busy investigating and looking for, and then you say, no, I have confidentiality. Those are exceptions to the issue of confidentiality. Concealment of crime, and then threat to a party. Where there is a threat to the other party, you are bound as a mediator, irrespective of the issue of confidentiality, to make it Then admissibility of evidence in other proceedings. A party in the mediation proceedings, the mediator and any other third party, including those involved in the administration of the mediation process, shall not in arbitral, judicial, or similar proceeding rely on, introduce as evidence, or give testimony or evidence regarding an invitation by a party to engage in mediation proceedings, or the fact that the party was willing to participate in the proceedings, or views expressed or suggestions made by a party in the mediation, or statements or admissions made by the party, or proposal made at the mediation, or the fact that a party had indeed indicated its willingness to accept a proposal or a document prepared solely for the purpose of mediation proceedings. Now, all of these things, somebody will come and say, you are claiming 10,000 naira. Okay, I agree, I will pay you 5,000 naira. That admission and whatsoever you discuss, including documents you presented in the course of mediation, Once a mediation fails, it stops there. You cannot pick those things and say, okay, you are going to go and use it in court. You say, in fact, I have the recording that this person admitted to this thing during our mediation. You cannot make use of those things. So, subsection 2 applies the information or the evidence referred to. Settle, that brings an end to the mediation proceeding. It is declared terminated. Then, when it is declared by the mediator, to the effect that the further efforts at mediation are no longer justified on the date of the declaration. Now, once the mediator says that these parties cannot settle via mediation, that ends it. Now, this also calls for the responsibility of the mediator. We have taught you, and you get to know in the course of the training, that a mediator must be committed to the process of mediation. He must be committed from the beginning to the end, because at any point in time he says that mediation has come to an end, then it has come to an end. So he must persevere, he must be professional, he must insist, and he must do everything within his power to ensure that parties settle. By this routine, by now, I bet just go away. It is your problem, it is your dispute. I'm just helping you, please go. When you behave in such a way, it will come to an end. And when you go to court and they say, don't you attempt to settle? They say, no, we attempted to settle, not knowing that it is the unprofessionality of the mediator that brings the mediation session to an end, because he declared it to be so. So you have to be very, very careful and ensure that you perform your duty as expected. Then a declaration of the parties adheres to the mediator to the effect that the mediation proceedings are terminated on the date of declaration. You know, mediation is party driven. Once a party says it's not interested again in the mediation, or the parties have agreed that they are not going to continue, that brings it to an end. There is nothing. I have a mediation at the multi-law house. They filed the process and the paper for mediation. Then the lawyer filed a notice of preliminary objection before me. And then I was like, which one is this one? At the end of it, they did not consent. They did not even sign the agreement to mediate, that they are not interested. And that is how the mediation comes to an end. You cannot force it on them. In declaration of determination of the mediation provider administering the mediation, if you say settlement house to administer the mediation, and settlement house come out to say this mediation has terminated, then it stands terminated. So these are some of the things that you need to take note for the determination of mediation. So, as we conclude on this, are you permitted to act as a mediator as well as an arbitrator until it is otherwise agreed by the parties? Unless otherwise agreed by the parties, a mediator shall not act as an arbitrator in respect of a dispute that is the subject of a mediation proceedings. Remember, we said that if a judge has helped parties to settle a dispute before, and the thing has failed, you cannot come back and say you are adjudicating over the matter. So here, where the mediator, you have served as a mediator, and the party, the matter did not settle, you are not supposed to continue and act as an arbitrator. Unless if the party says, okay, please go ahead, you should act as the arbitrator. So everything is subject to the parties to decide. So they said the dispute that was or is a subject of the mediation proceeding, or in respect of another dispute that has arisen. So you should take note of that. Then another thing is where parties have agreed to mediate and have expressly undertaken not to initiate arbitral or judicial proceedings with respect to or an existing or future dispute during a specific time until a specified event has occurred, such an undertaking shall be given effect to by the arbitral tribunal and the court until the terms of the undertaking has been. This is emphasizing the power of the parties to decide. Immunity of the mediator cannot be called as a witness. They say, he was the mediator. All these confessions and agreements were made before. Let us call him to come and testify. You can also call the mediation provider unless their action or omission is shown to have been in bad faith. So before you can say you want to call them the mediator or the mediation provider, you must show that there is bad faith in the way they administer it. And so now, as to the issue of bindingness, they said where parties conclude an agreement settling a dispute, the mediator shall participate in the preparation and drafting of the settlement agreement. So you should know how to prepare. If you are not a lawyer, simply you assist them. But if they have lawyers, the lawyers can help them. So subject to section 86 of this act, settlement agreement resulting from mediation is binding. I hope you are hearing me. It is binding and it is enforceable. It is binding and it is enforceable. It is binding and it is enforceable. Remember, as in the court as a contract, yes, as an agreement between parties, or as consent judgment. The parties court will call you, is this what you agreed? Yes. And then they will make it the consent judgment, the judge will sign, or consent award. You can go with mediation, and if you agree, whatever you agree, it will be passed as an award, and you know awards are generally enforceable. Now, if you want to enforce your settlement agreement, you are supposed to provide a signed settlement agreement that is signed by the parties, and there should be an evidence that this settlement agreement is resulting from mediation. And if you are going to show that it results from mediation, you need the mediator's signature on the settlement agreement, or you also need a document that is signed by the mediator indicating that the mediation was carried out. Not that you are going to go and forge something and say this thing is done. The mediator has to attest to it, and there should be an attestation by the mediation provider that administer the mediation. Most times, if you can get a notary public to attest to the fact that this thing has been carried out, that will make it even more viable. So you should take notes of that if you want your agreement to be enforced. Now, the requirement that a settlement agreement shall be signed by the parties, or where applicable, the mediator is made in relation to an electronic communication. Now, this one's aspect that I can just read. I explain the basic aspect from the commencement to the end of the mediation, and they told you that it's enforceable. But there are instances where a party can say that you cannot enforce. Where a party to the settlement agreement was under some incapacity, someone of 15-year-old, and you say you have made an agreement with him, it is not enforceable. Then settlement agreement sought to be relied upon is void. You have a settlement agreement, but that settlement agreement is void due to one reason or the other, or that it is not binding, it's not final. You just have an agreement and that agreement is not conclusive. That can be a ground for refusal for enforcement, or that it has been subsequently modified. You have agreed that the person will pay 10 naira, then later on you say you will pay 15 naira. That particular one is not enforceable. Then the obligation in the settlement agreement has been performed. Pay 10 naira and you are paid the 10 naira, then you cannot go and start enforcing again. So it is not clear or it's not comprehensive. So basically, these are some of the things that you need to know about this. And we are going to send you the law. Take time to look at it. It is a very, very interesting aspect of this training that you need to know as a mediator. and that will guide and regulate the kind of things that we do. So with this, I can say thank you very much. Mr. Lloyd is here with us, and I will try to just introduce him. Are we all together?
Yes.
Yes, sir.
Okay. So we have our third facilitator here with us. He has joined us as early as 9 o'clock. And it will be a very interesting time to have him guide us through the issue of opening statement. You know, we believe in practicals. We believe in you knowing this thing properly. And Mr. Lloyd Comita is someone, he is a lawyer by training. He's a lawyer by training, and he is one of the top mediators in Florida in the United States of America. He has facilitated the resolution of a lot of disputes, and in fact, he is among the people who train persons to become mediators. You know, he's a trainer. You know, he is a trainer, and he is the president of the Mediation Training Academy in the United States of America. I just want to share with you his. Okay, so briefly, we are going to send you also all the profile of the facilitators so that you get to know them, you get to connect with them. They're actually all available on LinkedIn. You know, they are all on LinkedIn. You can connect with them, you can reach out to them, you can ask them questions where necessary, you know, and then interview. So having said so, I will want to Mr. Lloyd Comita is okay. Good. Now, okay. Mr. Lloyd, sir, are you
Good
with us?
afternoon.
Yeah, it's good afternoon here. Yes, so here is Mr. Lloyd Comita. He is actually the president of Mediation Training Academy in the United States of America. He's an attorney in Florida, and is very vast and experienced in mediation. In fact, he trains people in mediation. People who want to become mediators. He actually, aside from training, he represents parties and people in all the court connected DR centers, and you know he has a lot of disciples, so to say, a lot of mentees and people who are looking up on him, and he has been in this field for several years. It should be an honor, sir, to tap from your experience from this people. Thank you very much, sir. I hand over to you.
All right. Well, thank you, everyone. And thank you, Nanchang, for having me here today. I'm assuming I don't see anyone's face but Nanchang's, but I assume people are here and maybe the cameras are off because of the Wi-Fi signal.
Okay,
And it's
please,
better.
can I ask you all to turn your camera? It will be good for him to be able to see you because this is a practical aspect that you want to. So please, we will implore you to put on your camera so that we will all see ourselves. Thank you very much.
Okay, and some of them may not be doing it because of the Wi-Fi signal, and that's okay. So I just want to first apologize for the way I'm sitting. I'm sitting at an angle, and that's because I recently had surgery, and my whole hip is all still healing, and so it's hard for me to sit all day. And so we'll get through this training and see that we're recording. So again, I want to thank Nan Chang for having me here today. I know I missed the last couple of his training sessions, and I really enjoy training around the country. And I'm looking forward to working with everyone today. So again, my name is Lloyd Commodore. I'm an attorney in Florida in the United States of America, and I am the president of Mediation Training Academy, and I train those who want to become certified mediators in the state of Florida. The first step is that they have to take a training program, and I have one of those training programs, and there's other things that they need to do. But Nan Chang has asked me to speak on a couple of topics, so I'm going to be with you today for the last, I think I'm your last session of the day. I promise you, you'll get out by 4 o'clock your time. And tomorrow I'm going to be talking about the stages of the mediation first thing in the morning or early in the morning. So I'm looking forward to that. But right now, what we're doing is we're talking about opening statements. And we're going to learn that there are several reasons we give opening statements as mediators. And what I'd like to do is go over those reasons. We give a opening statement, talk about the elements of an opening statement. And then what I'd like to do is put you all in breakout rooms and have you work on an opening statement. Because throughout the program here, you may be doing mediations. And when you leave here and do other mediations, other work, you're going to want to give an opening statement. So with that said, does anyone want to take a guess or crack at why we give an opening statement? And if you don't know, that's okay, because I'm going to tell you. So there's several reasons we give an opening statement. One of them is in Florida, it's an ethical obligation. Under the rules of mediators here in Florida, we have to give an opening statement. And there's certain things we have to say in that opening statement. I have not read the mediation rules in Africa or Nigeria, so I'm not sure what they say as far as opening statement. But here we have an ethical obligation. So that's one reason we give an opening statement. The other reason is we want to give them education. We want to educate the parties and the attorneys of what's going to happen today. Some of these attorneys and some of these parties maybe have never been to a mediation and don't know what it is. So our role is to educate them and give them guidelines. We want to talk about such things as confidentiality, because everything said in mediation is confidential except where disclosure is required or permitted by law. Can't hear anything. Hadiza Lawal, can you hear me? Give me a thumbs up if you can hear me, Hadiza. Nimnan Denden, can you hear me? You're on mute. Okay. So apparently you all can hear me. So maybe whoever said they couldn't hear me, maybe it's something on your end. So Mugu Stephen, can you hear me?
Yes, I can hear you, sir.
Okay, perfect. So then I know it's not my end. I would never like issues on my end. So we want to talk about things such as confidentiality. In Florida, everything said in mediation is confidential except where disclosure is required or permitted by law. We want to talk about the logistics of what's going to happen today. We want to talk about who's going to speak first and why they are speaking first. We don't want to just say so-and-so is going to go first with their opening statement. So we want to tell them we're in control of the process. So we're going to talk about who's going to speak first and why. We want to talk about the roles that we play. As a mediator, we do not have any authority to tell them what to do. We don't make any decisions for them. We help them communicate back and forth. That's what our role is, to help them communicate. We also want to talk about the other reason we do it is because it sets structure to the process. It sets the foundation. And basically what we have is in the outside adversarial world where everyone is fighting, and they come into our room for the mediation or on our Zoom call for the mediation, the opening statement serves as this transition from this outside adversarial world to this world where we're here talking as people. We're here just to communicate to see if we can come to some sort of resolution. It's our safe space. And it's that transition that serves as that safe space. The other thing is we want to set the tone. We want to show that we're in command, that we know what we're doing, and you can trust me. And when they trust me, then they are more likely to talk more open and more freely. And when the parties are talking more open and freely, they're more bound to settle. Now, a couple of things that we want to make sure we say in the opening statement. We, of course, want to figure out who is there. So we want to ask them. And maybe it's a case of John Smith versus Sally Jones, and there's only two people there, John and Sally, so we know who they are. But if we're assuming if the corporation is a party to the lawsuit, we don't know who's there. So we want to ask everyone who is there. And on Zoom, you can change the names on your screen so you can remember who is there instead of just having a phone number or something that says iPhone or iPad. You can actually type their name on. So figure out who is there, how do they want to be addressed? Mr. and Mrs., John Smith, just John or Sally. Figure out how they want to be addressed. If you're on a Zoom call doing a mediation, you may want to trade phone numbers. In case people get disconnected, they can call in. Also on Zoom, we want to make sure that they're in a room by themselves and that no one else is there because everything said in mediation is confidential. All right, so we're talking about confidentiality. We're talking about reaching an agreement. Maybe the parties are going to reach an agreement, and if they do, then everyone will draft up an agreement, everyone will sign it, and then everyone goes home and does what the agreement says after the judge approves it. At least in Florida, the judge approves the settlement agreements. And we're called about if there is no agreement. If there's no agreement, the case is just going to continue on doing whatever the next procedure is in the case. Maybe talking about note-taking. I don't personally talk about note-taking, but I know some mediators do. I know some mediators say, I may take some notes. At the end of the mediation, I'm going to destroy those notes. Or at least in Florida, there's no rule that says you have to keep them or destroy them. I save them. I don't know what the rules are in where you guys and ladies are located. We're going to talk about how it's an informal process. We're here just relaxing. There's no judge here. There's no jury here. There's no bailiff here or policeman hovering over us. It's just you, me, and the other side, and we're just talking about the case to see if we can come to an agreement. We want to make it a consensual and involuntary process. We're not going to force anyone into signing the agreement. The parties are the decision makers. In mediation, the ultimate settlement authority rests on the parties. I can't tell them what to do. The attorneys can't tell them what to do. And their friends and neighbors can't tell them what to do. We may have ideas, we may have suggestions, but the ultimate decision-making authority rests with the parties. We're going to talk about who goes first and why. Typically, the one who files the lawsuit, here in the United States, they're called the plaintiff. Because they're the ones who file the lawsuit, they're the ones who are going to go first with their opening statement. So the process is, and I'm going to talk about the stages of mediation tomorrow, but the process is basically, in a quick nutshell, is I, as the mediator, give an opening statement, then both sides give an opening statement, and then we go into the mediation. So we're going to talk about who's going to go first. So typically it's the plaintiff, the one who files the lawsuit, is going to go first. If it's a pre-suit lawsuit, maybe someone requested the mediation, so I'll let them go first. But if I don't know who went first, then I'm going to say Ornella is in my upper left-hand corner on my Zoom screen, so Ornella is going to get to go first with their opening statement. That's why there's some reason that I picked Ornella. Because if I don't do that, and if I say Ornella is going to go first with their opening statement, then what's going to happen to the other side? the other side is going to think that I am siding with Ornella and letting Ornella go first. So I start off by saying Ornella's going to go first because they're in the upper left-hand corner of my screen or the upper right-hand corner of your screen, whatever you want, some reason why that person's going to go first. Then you're going to want to talk about separate sessions, private sessions, and these are called caucuses in the mediation world. And in the Zoom world, we use breakout rooms. So we want to let them know that we are going to go into caucus at some point, maybe not, but more than likely we're going to. And when I go into my caucus, I always remind the parties and the attorneys that everything said here is confidential, except where disclosure is required or permitted by law. But we'll talk about that more later tomorrow. So we're going to be talking about caucus. That way, in case it happens in the middle of the mediation, someone doesn't say, oh my gosh, they said something and now the mediator wants to speak to me privately. So that way, if we say it in the beginning, then people aren't going to read into it. Maybe talk about housekeeping issues like timing. How much time do we have for mediation today? Some mediations are limited to 2 hours. So if you want to talk about that, talk about that. That's fine. There's nothing wrong with that. And at the end, I typically don't tell people to behave themselves in mediation. And the reason I don't say that in my opening statement is because to me, that's a negative. If I tell people to behave in mediation, it makes them think that I don't think that they know how to behave. And I want them to think they know how to behave in mediation and that they're not going to interrupt each other when the other person is talking. And they're not going to be shouting at each other. So I don't say that in my opening statement. Now, if in the middle of the mediation, someone starts interrupting someone, then I'll stop them. Okay? Because I can't hear two people talk at the same time. So I'm going to talk about, I'm not going to talk about the behavior so much in the very beginning. And then I ask at the end if anyone has any questions about anything I just discussed. Any questions so far? What I'm going to do now is I'm going to give you my typical opening statement on a small claims lawsuit. And it goes something like this. And I'll extend the opening statement depending on the circumstances. If I get word that one of the parties is belligerent and doesn't want to settle and is fighting everything, I'll go into a little bit more. But my basic opening statement says something like this. Good afternoon, everyone. My name is Lloyd Cometer, and I'm a Florida Supreme Court certified county mediator, and I'm going to be mediating this case today. Mediation is a process where we sit in a lovely Zoom room such as this, talk about the issues in the case, and see if we come to some sort of resolution. If we can resolve the case today, the parties will enter into an agreement, and then everyone goes home and does what the agreement says after the judge signs off on it. If we can't come to an agreement, I will declare an impasse or no settlement, and then you folks will continue on doing whatever you need to do next in this case. Some of the rules for today is anything discussed here stays here. What I mean by that is we don't go home and tell our friends, neighbors, and loved ones what went on in mediation. We especially don't tell the judge what went on in mediation. And the whole point of that is to foster open dialogue, open communication, knowing anything you say won't be used against you later on. Certain exceptions to that are when disclosure is required or permitted by law. Procedurally, we're going to hear from Ornella first because Ornella is the one who filed the lawsuit. They're going to tell us what their position is. And then we're going to hear from Nahid, Abdallah, and they're going to tell us what their position is. And then we may go back and forth. We may have some questions amongst each other. We may want to stay as a group. But at some point, you may want to speak to your attorney. Your attorney may want to speak to you, or you may want to speak to me, or I may want to speak to you privately. In mediation, we use caucuses. In the Zoom world, we use breakout rooms. And if I call the caucus first, I don't want anyone to read into it who I speak to first or for how long. I just find that's the best way to work through the issues. Feel free to call me Lloyd. Is that okay if I'll call you by your first names? Lloyd says yes. And then I go look at Ornella. Okay, Ornella, why don't you tell us why we're here? And that's my opening statement. It's about 3 minutes. It doesn't have to be a 20-minute opening statement. It can be short because they don't need to know your whole background, where you went to college, where you went to school, and how long you've been a mediator. because either the judge has assigned you to mediate the case, or typically the attorneys have picked you to mediate the case, and the parties are relying on the attorneys. So it doesn't matter about where you went to school and how long you've been practicing law. I may talk about those kind of things in a private session, but not in my opening statement. Any questions, comments, thoughts, or concerns about opening statements? All right, what I want to do now is I'm going to put you in breakout rooms as a group, and I want you to draft an opening statement. It doesn't have to be perfect. You're going to be working on it over time throughout the program. You can build, at least want you to start drafting something of an opening statement. And then, depending on how much time we have, maybe one or two of you will give us your opening statement as a practice. Does anyone have any questions on what I want you to do? All right, now I was trying to see if I had access to the breakout rooms, and I do have the access now. So I'm going to assign, so Nan Chung, how many people are with Settlement House that are like administrative people that I'm not going to put in the rooms? Do you know who that is? Is it just you, or are there other people here too? I lost Nan Chung.
We have, I think all of them are participants.
Okay, so you're the only, well, you and me are the only instructors here right now, correct?
Presently, I'm the only instructor.
Okay, so you and me. So
Yes.
that's 20 people. I'm going to do 5 breakout rooms. So let me set up the breakout rooms, and I'm going to create 1, 2, 3, 4, 5. And I'm going to, I don't know any of you, so if any of you don't like each other, I apologize. If some of you don't like working with each other, I apologize. But we are going to work on it together. And basically, I'm just doing it randomly. 5 people in each room, except for myself and Nan Chang. And then what I want you to do is I want you to start, hopefully you have paper or you have a computer and pen or paper, and you can start working, drafting on an opening statement. Actually, I did too many people. I want to do one thing. Hold on, let me, I'm going to put some people in other rooms. 1, 2, I'm going to put some people in room 5. So 5, room 5, room 5, room 5. So I got 4, 5. So I got 5 rooms of 4 people each. I want you to talk to each other. I want you to interact with each other, and you can work on it together. But I want you each to draft your own opening statement. So you're going to do it for about 15 minutes or so, because I want to make sure I get you out by 4 o'clock. So work on it for about 15 minutes or so, and then we're going to have 1 or 2 of you give an opening statement, okay? Any questions from anyone? All right, so I'm going to open up the breakout rooms. You should have a signal on your screen that you can join your breakout room. So I need you to join your room. I need you all to go to your rooms. Ibrahim, can you join your room? Nahid, can you join your room? Agnes, can you join your room? Abimbola, can you join your room? They may not be here. Let me see if I can move some of them. Ibrahim Opeyema, can you join your room? Agnes Nahid Adiwumi, can you join your room? Ibrahim Opeyema, can you hear me? Nahid Abdallah, can you hear me? Agnes Lolo, can you hear me?
Yes, I can hear you.
I need you to join your room and work on your opening statement.
Wow.
Can you join your room?
Oh, which one is my room, if I may ask? I'm just joining.
We're doing breakout rooms right now.
Okay, you're going to break out now.
Yes.
Okay, so you're going to
in room
assign me
number
to
one. You're in room one.
Okay, room one. Okay.
Adiwumi Anthony, can you join your room?
All right, sir. All right, sir. Just see now I can join now.
Adiwumi, you're going to be going into room one.
Okay.
Agnes, you're going to go to room one.
Okay, sir.
Agnes, are you going to room one? Jobs iPhone, are you lost?
I'm lost. I'm lost. I don't know how to go in.
I can't move you. Let me move Jobs. Jobs iPhone, do you know what room number you were in? I'll move you into 3. Agnes, you can't go to your room? Ibrahim Opeyemi, can you go to your room or no? All right, ladies, if you're not able to go into the breakout rooms, then I need you to work on your opening statements amongst the two of you. Okay? So we're going to draft opening statements, and if you're not able to go to your breakout rooms, then work on it amongst yourselves. Can you guys hear me or no? Eddie, Manuela, Stephen, do you know what room you were in? Corey Elias, what room were you in? Do you remember? Ah. All right, everyone's slowly coming back in. So I think this is everyone. And we only lost a couple people in the break room, so not too bad. All right, so again, I don't expect you to finish your opening statement now. It's just there wasn't enough time for it. But does anyone want to give us what they have so far? And I heard one that was started and some comments were given to that person. So does anyone want to give us peace, Bolaji, blessing? I think we have a hand up. You want us to give us your opening statement? You're on mute now.
Yeah.
You're on.
Good afternoon, sir. So here goes a little bit of what I have drafted as my opening. Good afternoon. My name is Peace Bolaji. I'm a lawyer and a mediator. The mediation process is to help you both to communicate and reach an amicable settlement of this. While we go on, we may need to have some breakout sessions, but you can be rest assured that everything we discuss in the course of this process and even remains highly confidential. To this end, I would like the first person on my screen, name Grace, and then we go on to take Mr. Blessing. Thank you. That is what I have, sir.
Good. And again, as you work on it, you're going to get to a point where you're telling a story. And your story is going to be 3 or 4 minutes. But some of the things I think you left out is you didn't figure out who was there. I think that's important. And we want to talk about, I think I stress a little bit more about confidentiality. And then I would certainly talk about the caucus, expand on a little bit, describe what the caucus is all about. And, but no, I thought it was good. I could hear you. You had a good tone of voice, but just work on it and get to a point where you're telling a story. And it's going to come to you easier and easier. And I don't know what Settlement House has given you folks as far as any elements of an opening statement or any handouts for an opening statement. But if they did, I encourage you to look at that because you're going to want to do an opening statement at every mediation. All right. Any questions or comments or thoughts from anyone? Okay. I'm going to see you all I think it's tomorrow morning. And I would
have a
encourage you.
question.
Yes.
Is it only the mediator that gives opening statement or the
So as we're going to learn tomorrow, it's the mediator gives the first opening statement, and then the parties or their attorneys, if they have an attorney, they're going to give their opening statement.
Okay, sir.
They're going to tell you what the case is about because theoretically, you don't know anything about this case. So we want them to tell us what their position is.
Okay, sir. Thank you.
You're welcome. Any other questions, comments, thoughts?
Sir?
Yes.
I have a question, sir. Is it always the judge that will assign for mediation or others who are assigned for mediation? So like you told us that a judge assigned for mediation must it always be from the judicial house or private individuals or others that come for settlement for mediation?
So your question was a little choppy because of the Wi-Fi, but I think what you're getting at, and correct me if I'm wrong, whether you get the mediation from the judge or from a private parties, or they call you up privately or come to your house privately to do the mediation, it's important that you always give that opening statement. Is that what you were asking, a Godo Blessing? Nanchang, do you think I answered her question? Because it was choppy when the question was coming through.
Okay, I think maybe what she's asking is...
Yes, sir. Yes, sir. Yes. He got my question right.
Okay, good. So I got her question. So basically, every time you do a mediation, no matter how you get it, it's important that you give that opening statement. So everyone, regardless of whether they're in a lawsuit or not, or how you got it, they know the guidelines, this whole transition that we spoke about. It sets the tone and the mood in everyone. So that's important for every mediation, no matter how you get it. Any other questions from anyone? For those who are interested, I'm on LinkedIn. I heard Nanchang mention LinkedIn earlier. I'm on LinkedIn, Lloyd Cometer, and also Mediation Training Academy. I'd love to follow you and you follow me. And that's where we stay connected in this worldwide mediation road that we're all embarking on. So I think it's now 4 o'clock your time. And my time says that I'm supposed to end by now. So I'm going to turn it back over to Nanchang. It was good working with you all. Again, continue with your opening statements, and I will see you all in the morning.
Thank you, sir.
Okay, so thank you very much, sir. We are going to be having Lloyd tomorrow morning. And for some of you, I have the privilege of undergoing the training to become a certified county mediator in Florida, United States of America. And we are also working on modalities to see that for some of you who are interested in becoming Florida Supreme Court certified county mediators or other forms, we can work out modality to see that we get trained with Lloyd Committer. So please just have it at the back of your mind and let me know if you are interested, and then we'll work out modalities and tell you some of the expenses that may be involved and some of the things and the processes and procedures that may be involved.
Yeah, and I think let me add to that. If you want to do a private training program for your staff and your people in your area, I'd be more than happy to do that. We can have a conversation about that. So
all right. Thank you very much.
You're
all right.
welcome.
With this, is there any further question or comments? If there is no question, no further comments, take note that you need to be on your training platform and always try to read out information there. If you have not introduced yourself on the platform, please go and do so. And we are going to be sending some information and material concerning the training. Please do well to read out scenarios and some of the things that you need to know in your WhatsApp platform. Take note that attendance is very compulsory, and please try as much as possible to schedule this week for this particular training. It's just 5 days and day 1 is gone. You have just 4 days to go. I'll plead with you, try as much as possible to reduce other distraction or activities so that you can properly take part in this training. At the end of it, you should be proud that you have taken part in the training. And when they say you're a mediator, you know that you are going to do a good job. Don't miss out some of the parts of the information because the meeting is recorded and that you want to go through the recording. It cannot be as good as interacting and then asking questions where necessary. So if we don't have any further questions, can we call it a day?
Thank you.
Yes, sir.
Yes, sir. Thank you, sir.
All right, thank you very much. I'll see you tomorrow
Thank you,
morning.
sir.
Mr. Lloyd, thank you very much for coming
You're
in.
welcome.
Yes,
You're
we
welcome.
all wish you quick
But sir,
and
can I ask a question?
okay. Who is asking question?
Sir, Captain Kama.
Okay, go ahead.
Sir, actually, you know, like my own field of work, being in the military, most of our own way of mediating such issues, once we find ourselves in the field, and we find it's not that easy per se. It's easy, but not easy. But the civil populace sometimes don't understand us. Maybe our societal approach. You know, sometimes you find a crisis, you find yourself in a crisis environment where you you were sent to maybe to go and curtail the issue and this. Sometimes approaching that situation, you may end up, the people may end up not giving you the required attention. So, you know, such kind of things can lead to threat to somebody that's trying to maybe going to solve an issue where two communities communities clash or thereabouts. Sometimes, you know, you can't sign. So there are some kind of there are certain kind of people that don't want to go to that very scene. So we may end up finding ourselves in that very place. So what should be our maybe point of interaction or per se, or how can we go about it so that the people cannot see us being like a soldier will never go to a place without his arms. That's one. Because if you go plain clothes, normal, you may be attacked in such kind of situation. Now, how are we supposed to go to those people? How are we supposed to approach them without presenting such issue, being scared of being attacked or doing some counter attack because of such kind of issue? What should be our own rule?
Okay, Mr. Lloyd, would you like to take that, please?
So I'll be honest with you, I missed the beginning because it was choppy. Is the question geared towards how, when we dress in our military uniform as the mediator, how we handle the parties?
Yeah.
Well, it's not going to affect us. What was that, Nanchang?
Yes, in addition, he's trying to say he is a military officer, and sometimes they may be sent to curtail some situation. Maybe there are communal clashes, and then they are sent to curtail the situation. And those people there may not be cooperative, they may be hostile, so to say, to them. And then, you know, more so that, you know, when they are going to that environment, they don't just go in their plain clothes. They have to wear their maybe uniform and then carry their guns. And so maybe that also will help in creating a kind of animosity, so to say. So he is asking, how does he go about approaching some of these people in a peaceful way?
So what I would probably do in that kind of situation is really emphasize that I, as the mediator, am a neutral, impartial facilitator. My role here is to help the parties come to an agreement. My role here is to facilitate a dialogue. And don't even focus on what you're wearing, and don't focus on what anyone else is wearing. Just focus on how you are neutral, you're impartial, you're a third party who's working with you all to come to an amicable resolution. And I would keep emphasizing that. And then going back to what Nanchang was saying, what I would talk about is, you know, there's this outside adversarial world out there. We can't control that. What we can control is what's going to happen in this room. And if you want to have a say on what's going to happen in this room, then let's have a dialogue. Let's have a conversation. Because we may be able to come to an agreement. Whereas if we are in this outside adversarial world, you get no say. Your say drops down to 0. Whereas here, it's 100%. So I would emphasize those kind of things, talking to them, this whole self-empowerment thing. Does that sort of touch on your question?
Yeah, it is. But you know, why I bring such issue? Sorry, we are all Nigerians, sir. We are all here in the picture of there is a certain institutional issue that happened in one particular state where maybe there is a communal clash where some people were being taken and such kind of issue being trespassed between the both parties. So such people, there are some certain parts of some of our military men were sent there for a purpose, trying to understand what exactly happened, so that at least the two community can come together in a coalition. But an attack came to our own personal troops. Because I know the people were scared, thinking maybe the other community requested the troops, the military, to go for their own rescue. But not knowing then that the military are trying to come to go there so that the two parties can come together But that's why you see our societal approach, or sometimes I used to say, our societal approach, people don't understand us. They always see us like maybe if there's something happening in, like, for example, I'm in Abuja here, something happening in DADA with Garki. So once they see me in Garki, they'll be thinking maybe I'm siding the Garki people, not the DADA. So now, what, to me, if there is a way that if we are going for such kind of approach, maybe we may be attached to some mediators from the civil organization, maybe the lawyers or others, so that they can come up with a place whereby maybe they approach the people before we encroach in. But sometimes, you know, we don't understand the language. We were sent for a purpose, and they want us to act on that purpose. Before you know it, somewhere you may see yourself being attacked by an unknown person. So what do you think you should do? Because anybody that attacks you, you're trying to repel that attack back to that person.
So there's, if I understand your question again, there's nothing wrong, at least in Florida, United States of America, to separate the parties from the very get-go, from the very beginning. Put the parties in separate rooms. And you basically, as a mediator, are giving two opening statements. And the parties are separate, and they will never see each other today.
Okay.
And we just go back and forth. If we have an agreement, we'll take it, and they don't have to sign in front of each other. That way, it'll alleviate some of this animosity that you're talking about if they don't see each other. And again, emphasizing what your role is.
Okay.
My role is not to pick sides. My role is not to advocate. So in your kind of situation, in your kind of mediation, you're going to have to spend a little bit longer in your opening statements emphasizing what your role is and what the benefit is of mediation, because they may not know.
Okay.
They don't know. So in your particular case, you're going to have to do a little bit more of an opening statement, a little bit more of a stronger opening statement. My opening statement was just a general business dispute kind of case.
Okay.
Does that make sense?
So maybe
I get you now, sir.
In addition, you know, in the society, people just feel that maybe soldiers side with one side against the other, and for the fact that they carry guns, you know, they try to force their way. But if they see, like if you see for example, the protests that happen, you have some military men with their uniform, and they were sent out to be able to address the situation. And then you see also some police officers with their uniform. Some were actually forcefully against the protesters, but you see some exhibited maturity. They called the protesters, they addressed them. That is your opening statement. Your opening statement will help them to know the agenda and the reason why you are there. And once you get some of their leaders to understand that you are there to protect them, you are there to help them so that they can have an amicable discussion, you can use your power and your gun to go to the other side and without any form of attack, get the leaders that are in charge of that environment, bring them together, get the leaders from this side, bring them together, and then when you explain to them the reason why you are there, they can easily cooperate with you. But where they see you as siding the other party, you know, they will want to repel, they will want to oppose you right from there. So this kind of training that you are having will equip you with the ability, and I pray that you become a senior officer in the military where you have the power to make the command. Because if you are under someone and he says, go and do like this, you know, you have to go and do something different from what you intend. But if you are the one in charge, if you are the one in charge of the troops and you tell them they should hold on, the way and manner you approach the matter will actually bring success because you have the say, you are the, you can tell them stop, you can say move, you know. So that is how you do. Your opening statement is very important. And the way you react, if you enter the environment shooting, you know, just shooting and shooting, people will actually repel. But if you you are entering the environment with a symbol of peace and you are not shooting, you are just telling them to calm down. They will know that you are not going there to scare them. You are not going there to intimidate them. They will give you a listening ear, So these are some of the things you need to do. And in the course of the training, I believe that you are going to gain more strategies. These are strategies that you can begin to teach some of your co-colleagues, because the more you share the information, the better you understand and the better you retain. So you can share with some of your colleagues some of this information, especially if you have superiors, you share with them, this is what you attended and this is what you have learned. By the time they have the opportunity to attend trainings like this, it will equip them in their services. Do you understand?
Actually, Mr. Nanchang, I'm very happy and delightful to be part of it. Why? Because my mother introduced me to it. So finding myself at least adding more knowledge based on my own career, it's a very big plus to me. So I don't I'm not someone against learning. I always try to explore and understand more about myself, not only in the military, because the kinetic and non-kinetic approach which we use in the military, I need this most especially. I need it. So
thank you very much. Thank you very much for that, Mr. Lloyd.
I am interested in learning it.
All right, thank you very much, Mr. Lloyd. This is one final question, if you can attempt it, and then we close.
Okay.
My question is, how can we ensure that all parties express their statements and views openly in a case characterized by high tensions?
So, I would, and maybe do 2 separate breakout rooms right from the beginning. If you know this is a high conflict case, start off from the very beginning. Whoever shows up first, put them in one room. Whoever shows up second, put them in a separate room. That way, they don't have to see each other. And you go back and forth, and they never bring them back together.
Yes.
And then,
right.
what I would do, whoever is the bully, whoever's the one who's really driving this aggression, when you're leaving, let the other person leave first. Let them leave first, the one who is being bullied, the one who's in fear. Let them leave first. Let them get out of there. And then the bully can leave later, because you don't want the bully to leave first and then be waiting outside. Okay? That's how I would handle that.
Yes. All right, thank you very much. We are going to have more interactive and interesting session later on tomorrow. So with this, I think let us go and rest. We'll read off some of the instruction and materials that will be sent to your training platform and prepare against tomorrow. I pray that you come all ready with your materials. Please take notes. We don't share training materials till after your assessment, so that you will not be banking on the material and say, I will read up, I will do this. No. Take notes, and that is what you are going to use for your assessment later. Thank you very much and have a nice day.
Thank you very much.
All right. Have a good day, everyone.
Bye.
Thank you.
Bye-bye.
Thank you, sir.
See you tomorrow.
Have a good day, Nanchang.